Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. It is Tuesday, November 4th. Welcome to this sitting of the Appeals Court. I am Rachel Hershfang. To my right is Justice Paul Smyth. To my left is Justice Chris Hodgens, and we will be your panel today. I know many of you have been here many times before, but it's always worth a refresher. You get 15 minutes per side. There is no rebuttal in the appeals court, so don't save your favorite argument for last. We have read your submissions. We really have, I promise you. Feel free to jump right in. You don't need to give us the background. We got it. And there's no prize if you use all 15 of your minutes. If you've said what you need to say, feel free to stop there. With that, I will call the first case, Commonwealth versus Brandon Bamford. I'll remind the parties that this case is partially impounded, so please, no real names, refer to people by pseudonyms when necessary.
Good morning, Your Honors. My name is Attorney Carl Suchecki, and I represent Brandon Bamford.
Good morning.
In this instance, Your Honors, Mr. Bamford did not get a fair trial. At the end of the day, the judge gave a Tui Rodriguez instruction, and he essentially coerced the verdict in this matter. There were a number of jury questions during the course of the trial, during the course of deliberations. The first question was a legal question regarding why there were two indecent A and Bs, and the judge answered it, no problem with that. The second question from the jury was 3 hours in, and they asked, what are the next steps if the jury cannot come to a unanimous verdict? And clearly the jury is indicating that they're having issues in terms of coming to a unanimous verdict. The judge responded to that. He said, due to the short time, he's not going to say that there was an impasse. So he let it go, and then he sent them back in, and all he said was continue deliberations. But 5 hours later, he's concerned that the jury is going to be at a deadlock, and he doesn't want to have them come at 4 o'clock and say that they're at an impasse, so they come in the next day and he gives it to Rodriguez. He asked the counsel and decided that better to put it off to the next day, and that way he'd give him another chance to deliberate. So the court was recessed, and the next day they go to deliberations.
That timeline that you've laid out there, it sounds like the judge wasn't very good at coercion.
We're still early in the process here.
It took him quite a while to get there. And in fact, letting them go home early, that kind of cuts the other way, doesn't it? That he doesn't want him to rush. Just, take your time, come back the next day. Isn't that kind of being cautious?
I don't necessarily think that's the case. I think it's, he got agreement at counsel, so I think that it's fair to do that. But I think that he, at that point, had an inkling that there was an impasse. And instead of addressing that and letting the jury play out the way they were deliberating, he decided to curate it. He tried to control the setting and control what the jurors were doing, in essence. So he calls them back for the next day. And on the next day...
Well, I want to pause you there for a minute. First of all, that's Hodgens, that's Smith. So I know who they are, but I think I said them backwards. You know who they are, too, because they have name tags. Do you have a case where an inkling of an impasse is enough?
No, Your Honor.
Okay.
But it's a buildup. It's not just this particular.
Right. No, I understand.
This is the precursor. It's not. I will admit that the first one wasn't an impasse, but this puts it in their mind. That comes clear later when he does actually decide to do the TUI. In his own quote, he says that. This is a quote from the judge. It's been at it a long time. They've asked a couple of questions early on that gave an indication that they were concerned about being deadlocked. although they didn't say it, this is where they said they're deadlocked. And that was the one that they eventually decided to go to because they used the magic words. And Judge Leokos was very clear in Jenkins. He said that you don't need magic words. If you're dealing with Tui Rodriguez, it could be just the actual, and the words from the jury are they're an impasse, and that they haven't come to a decision on it.
We
So
review this for, this decision by the judge for abuse of discretion, right?
I'm sorry?
This is reviewed for abuse of
Yes,
discretion?
Your Honor, it is. Here it is. So on day 6, it's 40 minutes in, they come back after they had the early dismissal the day before. They ask the question, is it allowable to have unanimous decisions on some but not all indictments? Can a jury be hung on one of 4 indictments? So that's clearly that they're indicating that they're hung, but the judge doesn't find that that it's an impasse. He decides that the prosecutor says, I think at this point we need a TUI, but the judge responded that he's just going to answer the question because he has a question.
But the juror's language doesn't control, right? I mean, we have, I think it's O'Brien, where they claimed at an impasse, and the judge found they weren't necessarily at an impasse.
Yeah, but
so their language.
also, sometimes the plain meaning is there. And in this instance, you can actually see the progression every single time they're talking. There's an impasse. They're not unanimous. What do we do? What do we do? And the judge, instead of actually addressing that there's an impasse, he decides to answer the question and says the answer to yes is both, which is kind of avoidant on that issue.
Well, I mean, you know, again, abuse of discretion, right? So is it a clear error for the judge to have answered the question asked by the jurors? The jurors didn't say at any point, we're at an impasse and we want to be done. We're at an impasse and we want to go home. We have an impasse and some people are saying they want to be discharged. I mean, those things happen in cases. None of that happened here.
Well, and I would suggest, Your Honor, in question 3 and question 4, the third question where they say, is it allowable to have a unanimous verdict on some but not all indictments, can a jury be hung, is essentially saying they're hung. I mean, I don't think you can read it any other way.
I do. I think you can read it as, may we return a partial verdict?
Well,
And the judge answered, yes, you may.
I would view that as them saying that they're in an impasse, and then, of course, the next 3 more hours, they say that we've reached a unanimous verdict on 3 of the 4, on the other we're deadlocked, and then he decides to do the TUI. But at that point, I would argue that those are the 2 returns already, and at that point, he would need to get the consent, according to statute, the consent of the jury to go forward, because there are 2 impasses there. And if that's the case, the statute says if there's 2 impasses, you have to ask the consent of the jury to go to deliberate some more. Instead, he chooses the Tui Rodriguez, which, of course, is the dynamite charge. And it's very clear on this record that there were 3 not guilties, and they were hung on the one count that they found guilty on 40 minutes after the Tui Rodriguez charge. And our point here is that the judge had notice early, and to his own admission, he said clearly, they've been at it a long time. They've asked a couple of questions early on that gave an indication that they were concerned about being deadlocked. Although they didn't say it, this is where they said it, and they're deadlocked. But they did say it, and they tried to communicate it. And what he did was he didn't want to go there. He didn't want a mistrial. He didn't want a hung jury. So what he did was he sent them home early, and then when he got questions, he kind of took the short route. Oh, yes, I'll say yes to both questions.
Aren't you just speculating, though? Because we really don't know what the jury had decided on when they say that, well, we've reached a verdict on 3 of the 4 charges. You're just assuming that the one they didn't reach the verdict on is the one that is in dispute now, but it's possible they had already reached a verdict on that.
I think that's highly unlikely.
Why?
Your Honor, they said they're agreeing on three, and the 3 that they came back, there was only 1 guilty and 3 not guilty.
Yeah, but they may have agreed on a guilty. The first one out of the chute, they may have said, yeah, no, he did it, he's guilty. All right, now what about these other ones? And they were wrestling over the other ones. I mean, you're just assuming it as it favors your client, which naturally I understand why you do that, but that's not, logically, that's not necessarily the case.
I can understand that argument. I don't believe that's the case. I think that it seems clear to me on the record that they had wrestled with the one count of guilt. And especially prejudicial in this instance, where the Tui Rodriguez charge is the dynamite charge. It essentially kind of pushes them back to deliberations, and this judge kept pushing them back. He said, answer the question vaguely, or answer just not.
So where is it clear on the record, to follow up on Justice Hodgens, where is it clear on the record that they were hung or stuck on the guilty?
That they were stuck? The answer?
On the guilty, that it was on that one count, the guilty count. Can you point to the record where that's clear?
It's not as clear as I'd like it to be, but I think based on the record that it is.
Okay. And so it's abuse of discretion, but let's say we found that the judge erred. Then is it substantial risk because there wasn't an objection, or is it a per se violation of a Sixth Amendment right?
I think it's a substantial miscarriage of justice, and it is a violation of his constitutional rights. I do think that there were two returns, and it's a violation of the statute. They should have had a consent. They should have been asked to return as opposed to forced to post to charge, and then they come back with the guilty verdict.
So if it's a substantial risk, how do you make that showing?
Based on the fact that they come back and they're clear that they're in agreement on 3 and 1, and putting that argument aside, that it could have been that the guilty charge
But could have been doesn't get you to substantial risk, right?
I think that the substantial risk is the fact that he went to the TUI when there were two returns, and according to statute, he was supposed to have asked consent of the jury to go back into deliberations, and he didn't ask that consent. And if you don't ask the jury's consent, then you violated the statute.
Do you have a case, is there a case you cite that goes your way on this, where the judge, where the appellate court does find that the statute was violated or the returns were excessive?
I don't want to have one off the top of my head, but if you'd like, I'll
No, I
something.
thought there might be something in the brief that I had missed.
So it's our contention, of course, that Mr. Benford did not get a fair trial based on the fact that the TUI charge was given inappropriately, and that he should have followed the statute. And there were two returns, and they should have and did not get consent of the jury to go forward and deliberate further. In addition, our further argument is the closing argument, that the prosecutor committed error in closing argument for first saying and exploiting the fact and using that Mr. Benford was guilty because he had the opportunity to molest the child, and just because he had the opportunity does not mean that he did in fact do that. And it wasn't just an in passing reference to it. She did it repeatedly, that he had the opportunity and made it nefarious in the fact just because he was actually doing somebody a favor in babysitting their child when they had to work. And the worst part of the closing argument was the final thing the prosecutor said, and in that the prosecutor was in clear error for giving her own opinion regarding what she found and her conclusions, and she should not and did say, you will come to the same conclusion that I have, that the defendant is guilty of all indictments against him, and that's a clear error. And it should not have been as a violation of Mr. Bamford's rights, especially in a case like this where credibility was such a big issue that the prosecutor's voice carries sway, and it was a substantial risk of miscarriage of justice because it infected the case, and it was a very close case.
Back to the first issue. Is it your argument that the judge should have given Tui Rodriguez before he did, for instance, after the third question or after the second question even?
I think he could have. Whether he should have, I think if he, I mean, they came back with the impasse, so it would be appropriate, whether he should or didn't. I do think that when they ask when they asked the question, can we do 3 or 4 indictments, what he should have said or could have said was that we could have given a partial verdict. They could, in fact, they could have decided that, yes, we are unanimous on 3, and you can come back with 3, but on that 4th one, you can be hung, and we'll just get the partial verdict and retry the other one. Instead, he chose not to answer that question.
So he answered yes and yes, correct?
No, but he didn't answer regarding
Return.
what happens in that case. So if there's no further questions, thank you, Your Honors.
I see none. Thank you.
Good morning.
Good morning.
It pleases the court. My name is John Carmody. I represent the Commonwealth. I'm going to jump right into the Tui Rodriguez issue. As the court's already alluded to, this is the issue here is whether the trial judge abused his discretion and whether that abuse amounts to a clear error of judgment. Whether a jury is engaged in due and thorough deliberations and whether a jury is deadlocked, the timing of giving the Tui Rodriguez charge, how long a jury is required to deliberate, and the proper response to jury questions, those are all matters of the trial court's discretion. So the burden here on the defendant is to show that that abuse of the discretion was a clear error of judgment. I won't reiterate all the notes that defense counsel has gone through, but I would point out that notes 1 through 3, they're all asking a question. They're all asking a legal question. At no time do they say they're at an impasse, that they want to go home, that they're unwilling to continue deliberating. They are asking legal questions of the judge. And the judge answers those questions with the consent of defense counsel and the prosecutor. At that point, we get to note 4. That's the first time that the jury comes back and actually says, we are deadlocked. We are at an impasse. We have reached a unanimous decision on 3 counts, and we are deadlocked on a 4th count. And as you've indicated, we don't know which counts they reached the decision on and which count they had decided that they were deadlocked on. We don't know. It calls for speculation. Just as those notes 1 through 3 call for speculation that the jury is deadlocked when they are not saying they are deadlocked. So when that 4th note comes out, that's when the judge has made the determinations, 1, that they have engaged in due and thorough deliberations, that they are deadlocked. But more importantly, at that point, the jury's indicated that they have reached a unanimous verdict on 3 of the counts, and they are deadlocked on the 4th. That gives the judge every reason to believe that if they're sent back, if they continue to deliberate, that they may be able to reach a verdict on that count. So I would submit to the court that the timing of the charge was appropriate. The charge itself was appropriate to give at that time. And that's what happened here. There's no abuse of the judge's discretion. He thoroughly explained himself along the way that he didn't think they were deadlocked, they needed more time to deliberate, and that he felt that deliberation would lead to a verdict.
You'd agree, obviously, that it's the judge's role to determine whether they're deadlocked or at an impasse.
I agree with that.
The juror's language doesn't control, obviously. They could be out for 5 minutes and say, we're deadlocked hopelessly, but the judge will say, no, you need to go back and deliberate, correct?
Yes, and I think because the first part of that is the judge has to make a determination that they have engaged in due and thorough deliberations before you get to the point where the judge makes the determination that he or she believes that the jury is in fact deadlocked.
So they could be deadlocked before they indicate with a note that they're deadlocked. Or let me ask you a different way. At transcript 6 at 6, the judge comments, it's been a long time. They're asked, this is right before he gives a TUI, they've asked a couple of questions early on that gave an indication they were concerned about being deadlocked, although they didn't say it. This is where they say they're deadlocked. Is there a fair inference from that he was waiting for them to say they're deadlocked instead of interpreting their questions and independently finding whether or not they were deadlocked?
No, I don't think so. I think the judge may have been, those first questions come to the conclusion that they hadn't really fully and thoroughly deliberated yet, that they may be having some trouble reaching a verdict, But they weren't coming out and saying, we're at an impasse, that we don't want to continue. We're just asking these questions like, what happens if we can't? You know? So then they come back. When they finally are saying they're deadlocked, now the judge is saying, all right, I see now that they are deadlocked. I believe after 12 hours, they have
But for a jury to ask a court a question, isn't it fair to say, well, they're in the jury room and they're deadlocked. That's why they're going to ask the judge what happens if there's a deadlock. They're not deliberating. We don't know what they're saying, obviously. But it's not deliberating, well, we're unanimous on here, but maybe if we're deadlocked, let's just find out from the judge what would happen. I mean, it's a pretty clear sign that there's potential for a deadlock. Would you admit?
That there's a potential, but I don't think it's an indication that they're deadlocked. I think that it's just what you just said. They're deliberating. They may be having some difficulty, but they haven't. The judge it's in the judge's discretion to decide whether they've been at it long enough and whether or not they're not coming out to me and saying, we're deadlocked, we can't reach, we're just wondering what happens if we can't. They haven't said they're deadlocked.
And what weight do you put, or how does it factor into analysis? The trial, it's not what we consider, it's a very serious charge, but it's not that complicated. It's really whether they believe the victim or they don't. And there are 4 witnesses testify, but it's not multiple days, multiple exhibits. There's not a lot to sort through, and this went on for hours. At what point does a judge determine, in this case, that they have deliberated for long enough, considering the questions they've asked?
Again, I think that's one of the things that's in the judge's discretion, given the case, how long they've deliberated. But I think here, when they come out and they say, we've reached a verdict on 3 of the counts, and we haven't reached, we're deadlocked on the 4th, that it's within the judge's discretion to say, okay, they're almost there. Let's give them a little more opportunity to deliberate. And as far as the complexity of the case, I don't know that I necessarily agree that a case is complex because there's a lot of exhibits or the case went on for hours. Here, the situation was a case of child abuse brought forward years after the event, and the jury has to sit there and cull through all the testimony to decide. You know, there's a lot of issues there with the fact that it's a sex abuse case, that it's the memory of 5 years later of somebody, more than 5 years later, recalling what happened and then calling through all the inconsistencies that came about naturally because of the situation. I can't remember the exact date, I can't remember the exact time, those type of things. And then just briefly on the prosecutor's closing, I would submit that the entire closing has to be reviewed. The errors that are alleged have to be viewed in accordance with the entire closing and also the jury instructions. Here, the jury was repeatedly told that closing arguments are not evidence. The defense counsel actually twice during his closing argument reminded the jury and told the jury this burden rests with the Commonwealth. It always stays with the Commonwealth. From the beginning to the end, it stays with the Commonwealth. There was never any suggestion in the prosecutor's closing that the burden somehow shifted to the defendant. A prosecutor, of course, can't argue that opportunity alone establishes guilt, but they can show the jury that the defendant had the opportunity to commit the crime. There's nothing impermissible about that. And as far as his at the end, perhaps that was better left unsaid, but I don't think it swayed the jury. The jury acquitted on 3 of the 4 counts. I don't think they were swayed one way or the other.
Let me just ask you about that, because that certainly raised an eyebrow when I read through this, and maybe just for the benefit of people here to hear what was said, I think it's useful. This is the prosecutor now. I would ask, when you go to deliberate, that you consider the testimony that you heard from the Commonwealth's witnesses, and I would suggest that once you've done that, you will come to the same conclusion that I have, that the defendant is guilty of all the indictments against him. In your brief, and I understand you didn't author the brief, but there was no concession that that was an error, and it doesn't sound like you're conceding that that's an error. Would you concede that was an error to say that?
I'm not going to concede that it's an error, but I would concede that it was better left unsaid. It may have been...
Oh, it goes further than that. A prosecutor cannot say,
I would say it's
you
a
will come to the
harmless
same
error.
conclusion that I have, because the prosecutor is essentially endorsing,
Right.
vouching for the testimony of the Commonwealth witness, right? Or witnesses, right?
Right, but you do have to view the statement in the context of what preceded it. This was the last sentence of an entire closing argument.
Okay,
where you
so
had
it
marshaled
was
all
an
the
error
evidence.
then. You would concede that was an error, that should not have been said. Not better, better that it would not have been said. No, that was an error, right? That was touching the third rail. You don't say
If
that.
someone was to come to me and say, should I say this in my closing argument, I would say no, don't say it.
Absolutely not. Okay. So why does that error not create a substantial risk of a miscarriage of justice?
Because it doesn't, you have to view that error in the context of the entire closing, of the jury instructions, of the evidence. You can't, it's not viewed in isolation. It doesn't rise to the level of a substantial risk of a miscarriage of justice here. And I think that's indicative of the fact that there was no objection by it. So obviously, the defense attorney in the courtroom did not feel like this was such an outrageous comment that it was going to sway the jury. And again, the jury was instructed. These are arguments. These are not evidence, what the prosecutor says. And in the end, the defendant was acquitted of 3 of the 4 indictments. And I would submit that although it's a fleeting comment and although it's better left unsaid, it did not have an impact on the jury's verdict.
Doesn't the nature of the verdict weigh against your argument that it's harmless and that it did find not guilty on 3 counts?
What do you mean? I'm sorry, I didn't understand.
Again, if it were a very strong case and it was unanimous guilty, there'd be less likely a chance that a comment like this would have an improper influence on that verdict.
I think that kind of cuts both ways, because if you're going to say the jury, oh, the prosecutor believed her, so we should believe her, then why, if that's the mindset of the jury, they wouldn't have acquitted on 3 of the indictments. So that kind of cuts both ways. If your honors have no further questions?
I see none.
Thank you very much.
Thank you both very much. The case is submitted. Our next case this morning is 2024 P1351, Commonwealth versus Manuel Brunette-Silveira. Counsel, just take your time getting settled and let me know when you're ready to start. You look settled. Are you ready?
Yes, thank
All right.
you. May it please the court, Attorney Megan Areste for the defendant, Mr. Brunette-Silveira. This is an interesting case, but I'd like to just start off with a quick summary that it's well established in the Commonwealth that where a defense of lack of criminal responsibility is raised at trial, the burden rests on the Commonwealth to prove beyond a reasonable doubt that the defendant was criminally responsible at the time the alleged crime was committed. To overcome the defense of lack of criminal responsibility, the Commonwealth must demonstrate 2 things: that the defendant had the capacity to appreciate the criminality or wrongfulness of his conduct, and that he had the capacity to conform his conduct to the law. They must prove both this cognition and volition prongs in order to find guilt beyond a reasonable doubt. The Commonwealth did not do that in this case. In fact, they actively stated that they did not contest the defense expert's finding, which was the basis for lack of criminal responsibility. An experienced forensic psychologist opined at length that after a thorough evaluation of Mr. Brunette, that he suffered from schizoaffective disorder, bipolar type 1, that he was acutely symptomatic before, during, and after this event, and he was definitely not able to conform his conduct to the law and very likely did not understand the criminality or wrongfulness of his conduct. The Commonwealth chose not to rebut this testimony, nor did the evidence in its case in chief provide support to rebut criminal responsibility. So I think this is an interesting case. I have lengthy arguments on the volition and cognition prongs of that test, but I think it would be worth it to point out immediately that, it's a bench trial, right? So we have this presumption for this court that the judge properly instructed himself. And I think that if we look at cases like Lawson and Urikiel, that assumption fades where the record indicates otherwise. And I would argue that in this case, the judge not only didn't instruct himself, but completely ignored the prosecutor's statements of, we're not contesting this testimony, we're choosing not to rebut this.
Wait a minute. So clearly there was no blocking and tackling by the prosecution at all, for whatever reason. But that doesn't bind the judge, though, right? I mean, the judge is looking at the evidence. The prosecutor could sit there like a potted plant. Doesn't matter. The judge has to consider the evidence. And if there is evidence that shows that the defendant does have the capacity to commit these crimes, then the judge can rely on that evidence, right?
I think that yes, I agree. But I think that in this case, the evidence was not there. So if the Lattimore standard, and it does not give the judge, even on appeal, the Lattimore standard does not give the judge the excuse to ignore the fact that case law says once the defense of criminal responsibility, lack of criminal responsibility is raised, the Commonwealth must have provided evidence to rebut that. And even though they actively said, we're not contesting this, we're not going to rebut this, even if you say, okay, the judge could still look at the evidence presented and come to that conclusion, the evidence here was insufficient. Because when you look at the case law, you have something that in other cases, you have something that shows that the defendant had some control over his behavior or some premeditation or some acknowledgement.
But there was some evidence here. I mean, there wasn't a lot, but there was some. Because you had the defendant, he shows up at the courthouse and he's causing a disturbance. He leaves that area. Why would he do that? Maybe not to get into trouble. Where does he go? They find him, he's just sitting on some steps. He's not dancing out in the middle of traffic or doing something completely irrational. He's just sitting on steps. When they take him into custody, there's no difficulty transporting him. He's fine transporting him to the station. No difficulty booking. He is able to complete booking. All of that suggests that there's some, rational mind at work here. He's not so out of control that, he has to be restrained or they have to call EMS or something like that, that he's functioning. He's rude and belligerent. He's spitting at the officers, absolutely. But he is still acting, there's a modicum of rationality that the judge can rely on. Now, another judge might view it very differently, but this judge viewed it as being sufficient, and the evidence is there, isn't it?
I disagree completely. I think the interpretation of the evidence that there was some basis to say he was being rational and compliant is not there. I would say him wandering away from the courthouse, you'd have to speculate that he was somehow fleeing something, but the police officers approached him. He didn't flee. He immediately spit at him. His behavior continued to be irrational. The booking process was not smooth and compliant. They took him out. He tried to strike an officer. They put him back in the cell. They couldn't complete booking right away. It went on for a while, and his behavior in the cell included things such as excessively masturbating, eating his own semen, drinking the toilet water. I mean, the evidence was, and I think that's why at the end of, you have the prosecution saying we're not going to contest this, because this is pretty strong evidence of mental illness and inability to control one's behavior. There's no rational reason for any of those acts that he was committing. And his behavior continued once he was hospitalized. So I think, even if you want to say...
Can we look at that, though? I mean, I hear you on that. I know the record supports that his behavior continued after he was hospitalized, but when the judge is trying to determine whether your client was criminally responsible at the time of the offense, does the judge also accept post hoc evidence to try to figure that out?
I think that it's he can say, I'm going to not consider the defense, I'm going to look at the evidence the Commonwealth presented, but I think if you look at case law in Massachusetts, the evidence did not rise to what has been seen as sufficient to rebut the defense of criminal responsibility. So
I just want to make sure I'm following your argument. I think you used the phrase "the evidence" twice in that answer, but you were talking about two different things. So I want to make sure I understand. When you say the judge can consider the evidence the first time around, I think you were answering my question about evidence of the defendant's behavior, after he's hospitalized and so on, right? And then the second time, when you said the judge needs to consider the Commonwealth's evidence, I think you were just talking about the evidence that the Commonwealth put on in its affirmative case at trial. Okay.
Yeah, and I think when you look at the evidence if you disregard the expert testimony and you say the judge was within his right to do that here, if you look at the evidence presented by the Commonwealth, you don't have, when you look at other case law, you don't have anything that shows premeditation, rational activity. All the cases the Commonwealth cited to, as well as the ones in my brief, the court was able to say that there was some demonstration that, the defendant tried to evade the police. The defendant did some affirmative act, like draft their will, because they knew they were going to commit this crime. I think you have nothing pointing to premeditated or rational behavior. I think then coupled with the lengthy testimony from the expert, I think the judge at the end just was almost callous in his not instructing himself around the Commonwealth's burden. The defense was properly raised.
Didn't the judge expressly say, I don't credit the expert?
Yes.
So it wasn't a matter of neglect on the part of the judge or the judge misunderstanding something. He expressly said, I don't credit this testimony.
But what he didn't do was he didn't say, though case law, the law in the state that I am a judge in, requires me to consider was the Commonwealth able to, with their evidence, show that this defendant was both appreciative of his criminality and wrongfulness of his conduct at the time and able to conform his conduct. He doesn't talk at all about making that instruction to himself and making this decision, and that is what the law requires. So even on appeal under Lattimore, and even just looking at the case in chief of the Commonwealth, I think he fails to instruct himself properly and consider that the Commonwealth had a burden of proof that it did not meet.
So you're saying he has to put on the record his thought process? He has to state the McCool standard and how the Commonwealth met that standard or overcame that standard?
I think that, I don't know that he has to put it on the record, but I think from this record, it's clear that he disregarded it, because at closing argument on page 50 of the transcript, the Commonwealth explicitly states, we're not contesting the doctor's testimony at this time, and for those reasons, Your Honor, after hearing the doctor and reading those reports, the Commonwealth's determination is that we're not going to contest the doctor's findings. The court says, look, I can accept testimony, expert testimony, or any testimony, or I can reject it. In this particular incident, I'm going to find the defendant guilty. So I don't think that you have any analysis of, which was required.
You're saying the analysis has to be put on the record?
I think this case, there would be a stronger case for my opponent if it had been. But I think that it wasn't, and he just makes a couple of sentences that I'm disregarding. I think shows that we're arguing on appeal, that he didn't instruct himself correctly on the law when it came to the fact that lack of criminal responsibility was raised. And there was a burden shift to the Commonwealth to prove both prongs of that test. And the Commonwealth not only didn't do that, they actively said, we're not going to contest this or rebut this. And then when you look at their evidence that was presented, it was insufficient to satisfy either of those. So if he had stated that he made that analysis, I think my argument wouldn't be as strong, but I still think on the record, on this record, that the evidence was insufficient for either of those prongs, and I can talk a little bit about that, because I think there was ample testimony, from the expert that both he did not understand.
It was discredited, though, right? So, I mean, can we even be considering that at this point?
I think you can, because I think on appeal, even though, and I really thought about this a lot yesterday, but even though the Lattimore standard, and it's the light most favorable to the Commonwealth, the evidence in this case and the record is they're not contesting, and the evidence that they put forward was not sufficient to establish criminal responsibility. There's no evidence of that you see in the other cases of premeditation, of any acknowledgement that what his conduct, of what he's doing is illegal, that it's rational. His behavior was erratic, extreme.
Yeah, but when one of the officers is at the station, he's told by, I think, the booking officer, all right, why don't you go in the other room? Because clearly his presence just seemed to agitate the defendant. He went in the other room, and then the defendant was able to complete the booking process. So doesn't that kind of bespeak, okay, there is some level of rationality going. He didn't like the two officers who approached him on the street. There was some animosity there for some reason. He's spitting at them and so forth, striking them. But he's able to deal with the other officers in the station.
I think that you're assuming that he even knew he was interacting with officers. I don't think anything in the record or any of the testimony it's clear that his actions are in line with that he's even engaging with police officers. He's spewing profanities, he's spewing bodily fluids. He's not acting in a way that I think a fact finder could find him rational. And did they finish completing the booking at some point? Yes, but it was a long process because of his behavior. It's not like he got to the station. You've seen in other cases, there's one case that I have where the defendant gets to the point where they're interacting with law enforcement and understanding the law and saying they understand their Miranda rights and all that. You don't have that testimony in this case. You don't have any testimony of he was compliant through the rest of booking once this person left the room. I think you could try to infer that, but I think that's speculation.
So how do you interpret the judge's statement he's rejecting as a fact finder the expert testimony? For instance, the only evidence you have of the excessive masturbation and the drinking bodily fluids is from the doctor. It's strangely, the counsel, maybe not strangely, but the trial counsel didn't really cross-examine the officers. And the evidence of this behavior comes through the expert. And the judge allowed it, so you could argue that it's in, but then the judge said he rejected the expert's testimony. Do you think that's confined just to his opinions as to whether or not he appreciates the wrongfulness, for instance, of his conduct?
I do. I think he's choosing, it was lengthy, in-depth testimony from an expert who, I thought gave very balanced testimony and stated he often testifies for both the Commonwealth and the defense, but he chose to disregard that. I think that even looking, though, at the Commonwealth's case in chief, even without cross-examination, the evidence was not sufficient. And in a case where defense of criminal responsibility is raised, the case law tells us that the Commonwealth, the burden shifts. The Commonwealth has to rebut or present enough evidence that he understood the criminality and wrongfulness and could conform his behavior. It's not one or the other, it's both. And I don't think the Commonwealth's case in chief provided that evidence in this case, even if he was to completely disregard the extensive evidence that came in from the expert.
I think we'll have to leave it there unless there are questions. Okay, thank you, counsel. Good morning.
Good morning, Your Honors. May it please the Court. Megan Keene with the Commonwealth with ADA Dave McGowan, asking the Court to affirm the convictions of the defendant, because the evidence the Commonwealth submitted was sufficient to rebut any raised offense of criminal responsibility, especially in light of the defense's expert's testimony being rejected during trial. The judge was entitled to reject the defense expert's testimony and did not abuse his discretion in doing so because the expert himself could not reach a reliable finding of lack of criminal responsibility. As seen on page 43 in the transcript, where the expert does say that he could not reach a reliable conclusion on whether the defendant could appreciate the wrongfulness of his actions, and then later goes on to say that the natures of these allegations suggests that he was not in good conduct or good control of his behavior. And all of this evidence must be viewed in the light most favorable to the Commonwealth. And in doing so, we can infer sanity from the defendant's conduct.
So there's a little bit of slipperiness here, I think, at least as I try to get my hands on the law, about the burden shifting and who has what burden when, right? So, but as best I understand it, I think the defendant is arguing that once the defense of lack of criminal responsibility is raised, the Commonwealth then bears an affirmative burden to show two things: that the defendant did not lack substantial capacity to appreciate the criminality of his conduct, and the defendant did not lack the substantial capacity to conform his conduct to the requirements of the law. So focusing on the evidence that was presented in this very tidy little trial, what portions of the Commonwealth's evidence do you suggest to us are sufficient to carry that burden for the Commonwealth?
The testimony from both of the officers suggests that there was appreciation for the wrongfulness of his conduct. As Your Honors mentioned previously, he did leave the area where he caused the disturbance. And additionally, he was not spitting indiscriminately or at anyone or anything. He was spitting very directly at these officers, hitting them in the side of the head or the chest. Upon arriving at the station, he wasn't flailing. He made a threat to one specific officer that he was going to punch him in the face. Later on, he followed through on that threat against that same officer that he threatened, and only threw the one punch, hitting that officer in the shoulder. All of this, taken in the light most favorable to the Commonwealth, does point to appreciation for wrongfulness and ability to conform his actions.
Well, I mean, because it's ability to conform his actions because he's targeted only these two guys and not everyone? Is that the argument?
That is part of it, yes. It's also, there was the cooling time once he was put in a holding cell. He came out and found that one officer and was going to follow through on his threat against that officer.
How about his behavior in the cell? What are we to do with that?
As previously mentioned, all of the evidence about his behavior in the cell was contained in the defense expert's testimony, which was rejected by the fact finder in this case.
I'm not really sure how to read what the judge says here on page 51. I mean, he says, as a fact finder, I can accept expert testimony or any testimony, or I can reject it as a fact finder. In this particular incident, I'm rejecting that expert testimony. Are we supposed to understand that as being the equivalent of just wiping it from the record?
I believe we should read that as it is not taken into consideration during the deliberation process.
As the judge is deliberating, you mean?
Correct.
In place of the jury. So it's as if it never happened.
It's at least not playing a substantial role in the finding of guilt.
So the judge allowed in evidence on page 41, the trial transcript, the doctor testified again he was engaging in frankly very concerning and random bizarre behaviors. He was observed excessively masturbating, consuming his own semen. The court on its own initially struck that from the record, but then on the following page, the judge said, all right, I'll allow that testimony.
Yes.
So you're saying when the at the end, conclusion of the trial, and the judge says, I reject the expert's testimony, that he's no longer allowing that as evidence? Another way to interpret the judge's conclusory statement is he's not allowing the opinion. But as my colleague said, are you essentially saying the judge is essentially wiping out the doctor's the entirety of his testimony?
It may not be that it's necessarily being wiped from evidence, but we are getting down to whether this is, whether he's accepting the credibility of this witness, and this court does not revisit credibility determinations of fact finders from trial courts.
But this is the doctor saying this is what the police report said.
Correct.
It's not a credibility issue, I don't think, is it?
He did use the police report in his evaluation of the defendant, so it does play into his expert opinion of the defendant's behavior at the time of the offense.
Right, but the very specific question I'm asking is the behavior itself, because the only manner in which this description of the behavior comes in is through the doctor. Again, I don't know why counsel didn't cross-examine the officers about this, but the doctor is the only source of the information of what he describes as very concerning and random, bizarre behavior, and then he describes the behavior. So is that in evidence?
Yes.
You said earlier, I apologize in advance because I'm probably going to mess up this question, but I think you said earlier that the judge's ruling can be supported by the fact that the expert failed to opine decisively that the defendant lacked lacked the mental capacity, was not criminally responsible. I agree with you that the expert did not, there's one prong missing, right? But my understanding of the kind of the burden shifting shuffle here is that that's not really the issue before us. Once the defendant raises the challenge, the lack of criminal responsibility, the question doesn't, the appellate issue doesn't turn on whether he proved lack of criminal responsibility. It turns on whether the Commonwealth adequately rebutted that defense. Do you think I have that right?
Yes, I do.
Okay. Thank you.
Yeah.
Anyone else? All right.
If there are
Seeing
no
no
other
further
questions, I rest.
questions?
Thank you.
Thank you. The case is submitted. The next matter is, I don't think I said this, but we'll take a break after the third case. I forgot to say that, didn't I? Sorry. This is the third case, so everybody look forward to your break. Next up, we have Commonwealth versus BENJI GUERRIER, 2023 P1382. Whenever you're ready, counsel. No rush.
May it please the court, my name is Kevin Casilla, and I represent the appellate, Mr. Guerrier. Mr. Guerrier was seized in violation of the state and federal constitutions, and the police didn't have reasonable suspicion to believe that Mr. Guerrier had engaged in criminal activity at the time that they seized him. He was sitting in a car legally. That's when he was seized. I want to talk about the point when he was seized. So the video here in this case controls. I'm saying that the judge made some errors in his hearing at the suppression motion. The video here controls, and if you go look at that, you get to see for yourself whether you think from Benji Guerrera's standpoint whether he would have believed he was free to leave, whether he would have believed that the police would have used coercive force to stop him from leaving. And you get to do that independently. Com v. Tremblay, the other cases say that that kind of documentary evidence, such as the video in this case, can be reviewed independently. Also, the testimonial evidence that came in, you can review that, but you do that with deference to the trial attorney. And I do want to point out one error I think the judge made in the timeline there that matters on this. But that would have to be a clear error. And I think if he mixes up the events, that one happened before the other, I think that would be a clear error. So what I'm saying here is that excuse me 1 minute.
No, just what is the error in the timeline?
Oh, the second one?
What you said that there's an error in the timeline. What is the error?
Oh, let me get that for you. Here it is. With this new information and knowledge of Guerrier's very recent presence in the vehicle where a gun was present, and due to Shake's inability to keep his trembling hands where Capazzo could see them, despite Capazzo standing at the door beside him, he grabbed Shake's arm to keep him from repeatedly reaching towards the lower portion of his seat where his hand kept moving out of sight. In doing so, he could feel Shake's pulse rapidly racing. Capazzo asked if there were any firearms in the vehicle. They responded that there was only weed in the vehicle. Capazzo told them that he didn't care about the weed and that he was only concerned about firearms for the safety of himself.
So I think what you're going to tell us is that the question about the firearms happened before he grabbed the arm.
So the questions came first. So
okay.
You saw that in the testimony. All right, so I just wanted to point that out, that he did make this error, and it somewhat affects the analysis. Although my argument is that he was already seized at this point.
Yeah, so I'd like to focus on that, if you would, at least for now. When do you claim your client was seized and why?
All right. That's why I brought up the video right away, because if you go back and look at that video, he gets seized almost immediately when the police arrive. They come in with two cars that you can see in the video. A black one partially blocks the entranceway. The other silver car pulls in, right, and fully blocks that, and the police pile out, and with quite a show of authority, most of them head over to the group of kids. There's where 2 known gang members are and about 10 people who, you know, are just regular kids, I suppose, or who knows. But this is all being seen out the front window of the vehicle that Benji is sitting in, that Mr. Guerrier is sitting in. So he sees all this like at a drive-in movie. And so at that point, that's about when they get seized, and then Officer Capazzo comes over and stands next to them.
Wait, I want to stop you for a second. I'm sorry for being tedious about this, but this area of the law can get quite tedious. I don't mean that in a bad way. I mean precise.
I have hearing aids.
I'm sorry. I'll keep my voice up. Is this better?
Yes.
Okay. Thank you for letting me know. You say they're seized at the moment that the 2 police cars, or your client, at the moment the 2 police cars pull up and are obstructing the exit, right?
That, arguably, they could have been seized there because Mr. Guerrier could have believed he could not leave at that time, right? However, right after that, the officer comes to the door and starts questioning them, right? So I'm going to say that if you have to do the reasonable suspicion analysis at one particular point, it'll be when he elevates those questions about the gun. he starts, he's there, he's starting to, if it wasn't for the show of force and all that, and he had just walked up and started asking them casual questions, he gets to do that, right? And it wouldn't get to seizure until he asked it multiple times, which he does do, and that then affects a seizure, right? That's going to affect Mr. Guerrier's state of mind that he seized. So
Okay.
he's seized at this point. Everything coming after that is going to affect his state of mind. Grabbing Benji's hand, the increasing authority show they're pat frisking somebody right in front of his car. They do move the car out of the way, right, a bit. And you can see that in the video that Mr. Shakes turns those wheels and then decides not to leave and shuts the car off. This would affect Benji's state of mind. He
I
doesn't
agree
think
with
he
you.
can
I
leave.
want to slow you down because you're going through the question that we need to answer if we are going to rule in favor of your client is precisely the moment at which he was seized. And we need to look at that moment and decide whether there was reasonable suspicion to seize him at that time. And the reason I say him forcefully is because Commonwealth versus Mata very clearly said we are not relying on the state of mind of the defendant caused by things happening in the vicinity. Mata says we look at the totality of the circumstances to determine whether a member of law enforcement has engaged in some show of authority that a reasonable person would consider coercive. That is, behavior which could be expected to command compliance beyond simply identifying him or herself as police. And it is required, it's not the presence of law enforcement, it's acts toward the defendant. So I want to focus when we're talking about when your client was seized. I think the most helpful thing is to focus on acts that were directed toward him, not a group of police officers approaching 12 people in another area. I understand that's part of what he's seeing. It obviously goes to his mental state. I would not expect him to ignore it or to be non-reactive to it. But in terms of his own seizure, when is it that the police are communicating to your client that they will use their power to keep him from leaving?
That point would be when Officer Capazzo gets to the door of the car, even before he starts asking questions.
Just when he walks up to the car?
When he walks up to the car, those cars are, the other police cars are there, all that's in place that I already talked about, you see in the video, that's in place. When he gets to that door, Mr. Guerrier does not believe that he is free to leave.
But that analysis is dependent upon your assertion that he was blocked in, the vehicle couldn't leave, correct?
Impeded. Blocked is a difficult word because that implies that you absolutely have to have, no way out. Some stunt car driver could drive out of there. Impeded is enough. And those cars are in the way of getting out. A reasonable person is not going to think.
You write in your brief, sir, that the presence of the unmarked silver car stationed between the fence and the other unmarked car blocked his access to the exit. Are you now saying it wasn't blocked? It was just impeded?
That's, in the video, you'll see at that point they do have that entrance blocked. I was going to a point of law there that I probably didn't need in this case, but it is impeded. But in this case, when they have those two cars there and the police are getting out, they are blocked.
So you're saying that when they parked...
And Officer Capazzo is then standing there. Oh, sorry, I cut you off. Apologize. Then Officer Capazzo is standing there. At the point I'm saying, right, you've got two cars and a police officer standing there. Having to run over a police officer is effectively blocking you as putting a police car there. You can't, that's blocking. That's a seizure for legal purposes.
So I just want to explore the basis for your argument. So I think you had said a few moments ago that if Capazzo had just walked up to the side of the car to talk to Shakes, that would not have been a seizure.
If those cars weren't blocking him in, if there wasn't the other show of force, if they had parked their cars like regular parking, even if they did it in a police way that they weren't blocking something, because they usually, take a little advantage of where they get to park. If they had done that kind of thing and he had walked over and asked questions, he could have done that.
Does the free to leave analysis, or to go back to Mata, does the analysis of whether the police would exercise force to keep him there depend on him being able to drive away?
No, he's the passenger here. He would have to feel free to walk away, right? I think I'm going to use although I'm claiming he's already seized, when he flees, right, I think that shows that he didn't believe he was free to leave, because he runs. He runs really fast, and the police officer reinforces that he's already seized him because he immediately pursues him. Now, there's some case law that he can actually follow somebody even at that kind of a clip. You're running after Benji Guerrier, you got to go all out. But this is from Benji's standpoint. There's no way this 19-year-old man is believing that this guy is following him to observe him. He's trying to catch him, and that's what anybody would think. And so when he leaves, and he also he does a distraction thing when he leaves the car. He grabs some money and he throws it up in the air. That goes to show what he's doing there. He's trying to flee. He's not thinking he's free to leave or walk away. And he hasn't thought he was free to leave or walk away since those police came in and blocked that entranceway. That's where and I think that's a reasonable person in his place, 19-year-old man, would have believed that state.
So there's your client, and he's in the car with the aptly named Mr. Shakes.
Yes.
And then there's 12 other young men, roughly 12 other young men in the loading dock area when those police vehicles pull in. Are they all seized at that moment?
I don't know the analysis on if those people were seized.
What does that depend on?
If those folks over there had a way of walking out of there and knew they had a way of walking out of there, then you would have to individually analyze that for each one of those folks over there. I don't think you can do it as a group. But were some of those folks seized? They probably were, and maybe some of them weren't. That would have to be an individualized thing. I don't have the video. I don't have the interactions between the police that went over there, and I just don't have the information to answer that.
So are you saying that when someone jumps out of a car, reaches into his pocket and throws money up into the air and flees into the night, that the police can't follow him to find out what he's up to?
I can't hear you.
The police can't follow someone who jumps out of a car and...
Well, he could follow you, and we're talking about a pretty professional police officer, Officer Capazzo here. So he may have known himself, right, that I can follow this guy and keep an eye on him and see if I can develop something else, because he's doing this, right? But I don't have reasonable suspicion, right? That absolutely could be true for Officer Capazzo. However, the analysis isn't that for reasonable suspicion. It's whether, well, for reasonable suspicion, yes. But for the seizure, the analysis is what Mr. Guerrier, objective person in Mr. Guerrier's shoes would have believed. And there's no way he is believing that that police officer is following him for those reasons. In his mind, that guy's chasing me.
No, but I'm just saying, just as a practical...
But he can do it. He can do it.
It's not
and he's probably a good
unreasonable.
enough professional to have done that. But when he did it, right, even if he had a good reason, and even if that's why he was doing it, he would have effected a seizure, but he had already effected a seizure before that when he approached the car. But if he hadn't, that would have been a seizure in his pursuit. So there is a lot of seizures. You could also say, when they grab Shake's hands, they seize Shake's. Now, the case law would say that that also seized the passenger, right? So there's a whole lot of points along here where Benji just constantly gets seized. But the point being where I'm arguing as he gets seized all the way back when Capazzo approaches that door.
Okay. I think unless there are questions, we'll have to leave it at that. Thank you.
All right.
Good morning.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. Before I start, I did just want to note for the Court, I identified missite in my brief. Commonwealth versus De Vega is 489 Mass, 342, not 478 Mass, 342, so I apologize for that. I'd like to, if the Court will indulge me, just kind of run through the relevant considerations that factored into Lieutenant Capazzo's assessment of the situation. Obviously, the Commonwealth has a different view of the video and the testimony than my brother. In the Commonwealth's view, and I think this is supported by the judge's findings, while there were admittedly 7 police officers in, I think, 3 different cars that responded to this situation in the rear of the school, this was not a response to anything the defendant was doing. This was not, I guess, an apt comparison like the Palmer case that Your Honors all just grappled with, where 7 officers responded to one defendant who they specifically suspected of crime and were looking to interrogate regarding specific crime. This was officers responding to a large group of individuals who were drinking in public, loitering on the basketball courts, all of whom were, by their appearance, underage. And this was a response in a hotspot area where there had been town council meetings and specific determinations made based on a recent shots fired incident and gang violence in the area to increase patrol. So the response was to the group generally, at which point Lieutenant Capazzo testified, and I think the judge credited, as he approached the group in the parking lot, he observed this defendant who he was previously familiar with, along with Mr. Shakes in the vehicle. And I think the testimony bears out that Lieutenant Capazzo was the only one who veers off towards this car. At all times, and I think the video also supports this, by and large, every other officer that is on scene is focused on this larger group of individuals. It is just Lieutenant Capazzo who goes over to the car and does what the judge characterizes as a casual conversation with these 2 occupants. I do agree with my brother that at page 3 of the judge's findings, he kind of inverts that one thing that happens, right? I think the testimony was very clear that the last thing to occur before flight was the grabbing of the driver's hand, and that they were roughly contemporaneous with one another. So preceding that moment, you have an officer who is, while he does have police identification, you can tell he's a police officer, he's in plain clothes, you can see on the video. He's in shorts and a t-shirt. He's corresponding with 2 individuals in the car. He initially testifies that he is not asking them about firearms, but rather about this makeshift memorial that has been set up in the middle of the road next to the basketball courts because it presents a public safety hazard. He indicates that he only begins inquiring about firearms after his fellow officer retrieves a firearm off of a known gang member in the larger group, and that he's doing that at that point for his safety. And while I know there was dispute in the brief between my brother and I regarding the number of times he inquires about that, the motion judge's findings, which I think most accurately reflect the testimony, is that he asked once if there were firearms. The individuals in the car say no, and at that point, but there are drugs. And he says, I think as a follow-up, I'm not concerned about the drugs, I am concerned about a firearm. So I don't know if you want to characterize that as a second question, but essentially he's just saying, I'm just concerned about my safety, I'd like to inquire about that. Please keep your hands where I could see them. He said he's repeatedly asked Shakes to keep his hands visible. I believe he described Mr. Shakes as top 5 in terms of his entire career, in terms of nervousness. And so when Mr. Shakes again drops his hand below the visible area of the driver's seat, he grabs Mr. Shakes' hand. The Commonwealth does not dispute that that's a seizure of Mr. Shakes. I think the key fact here, as Your Honor, Justice Hershfang identified, is this is a situation where we have to look at the defendant. What actions were taken with respect to the defendant to make him think that police would coerce him to stay? This was clearly a very specific step taken that was directed towards Mr. Shakes based on Mr. Shakes' conduct. And so I don't think we can look at this, as I argue in my brief, as your typical car stop scenario where like police activate lights and sirens and pull a vehicle over and everyone is seized. These people just happen to be in a car when police approach an area. The car is immobile. When they first approach, it's not on.
I think it is on, actually. I think.
Oh, you know what? I apologize. It is on. It then comes off and is briefly turned back on when Lieutenant Capasso's attention is directed elsewhere and he's off screen dealing with other people. So I apologize for that misstatement. But this is not a situation where the defendant is blocked in. I included that screenshot from Exhibit 1 in the brief because I think it's important to look at that. I think it's also important to note, and I do regret not including another Google Maps image in a supplemental appendix, but there are 2 exits to this parking lot. So while I don't dispute that there are cars blocking off the Rush Street entrance, there is another exit point on Glen Street that is not blocked off. And the car that pulls up, the silver sedan, is, I would characterize it as 95%, if not entirely past the SUV, and it's also 3 or 4 feet away from it. So it in no way is
You're
pinning
talking
it.
now about the silver sedan in its second position.
Correct.
Right.
Correct.
But in its first position, would you agree that when the black police vehicle and the silver sedan are parked together, they are actually blocking both exits?
So,
Unless you're going to go overland. I mean,
so I think the tough part here is that the camera angle doesn't capture the entire width of the parking lot as you press up towards Glen Street. Really what it's showing you is up towards the Rush Street entrance. So there is more, it's a weird way to, the Commonwealth's position is there's more open space off camera through which a car could navigate. I'm not going to suggest to you that it would be clean egress. I think clearly there are obstacles to someone leaving. But this is not a situation where a car is being pinned in. And I would also note that earlier on, before that sedan makes its second movement, very little has happened at that point, right?
all right, so that's my next question, is does it really matter, in your view, legally, even assume for the moment, I know you don't agree with this, that the combination of the black and silver cars did block, at that moment in time, does it matter?
At that moment in time, the Commonwealth would submit that it does not, because if you accept the chronology that the judge did, at that point, essentially all that has happened is Lieutenant Capasso, because this is right, this is even before he walks away from the car for the first time. So all that has happened at this point is Lieutenant Capasso has walked up to the car in plain clothes, and he's engaged these 2 individuals in a general conversation that has nothing to do with firearms whatsoever. So the fact that further up the lot, there happened to be a couple cars that would make it difficult for the defendant to leave, I would submit in that circumstance is not the kind of restriction of movement that the courts are talking about. These are situations, the cases that the Commonwealth refers to in its brief and attempts to distinguish, are situations where the court found that the police car essentially is right next to the defendant's vehicle and has intentionally been placed in that location to prohibit it from leaving. Again, I think it's important to remember that no one knew the defendant was even there when they pulled up in their cars, right? Not until Lieutenant Capasso walks up to the scene and looks over and sees this SUV and sees an individual he recognizes in it, does he divert it? So when they are coming, their intention is to come and address the larger group by the loading dock, not to address any cars parked in the lot. There's no intentionality there to seize this defendant at that point. If we fast forward ahead to the moment of the defendant's flight, I recognize this court decided Palmer recently and that there are some similarities, but I think this is not that case for some of the reasons I've already stated and others. In Palmer and the sorts of cases my brother cites in his brief, again, we're talking about numerous officers that respond to a single defendant with the specific intention of detaining that defendant. And as in Palmer also, you're talking about a situation where multiple individuals who have called out to the defendant, who have attempted to get the defendant's attention to detain them, immediately follow and pursue when there is flight in response to that, either like, hey, you come here, hey, I want to talk to you. Here what we have, again, is one officer who is separate from the larger group dealing with the loading dock crew, who is talking to these 2 individuals in the car and who has taken steps as to the driver out of safety concerns. The only thing he's done as to the defendant is ask him whether he has a firearm, which our cases, I think, are pretty clear in and of itself is an appropriate thing for an officer to ask when he's approaching a scene and inquiring people without affecting a seizure. And so here, he grabs the driver's hand and the defendant immediately flees away. And you can see on the video, it's not exactly contemporaneous pursuit. The defendant is kind of around the silver sedan before Lieutenant Capasso takes flight after him. But I think the key thing here is if you look at Perry and you look at Shane S., it's still very clear from Sykes that it's a case-specific analysis. And Perry and Shane S. sort of talk about this absence of evidence that the defendant even knew he was being pursued. And here there was nothing in the record, nothing in the video. You don't see the defendant looking back. There's no testimony that the defendant was turning around and looking at Lieutenant Capasso. He doesn't draw his firearm. He doesn't call out to the defendant. He doesn't even radio in to other officers to tell them to go after the defendant until he makes the observation of the butt end of a firearm in his waist. So he's not even intending to have people detain this individual until he makes that observation. So on those specific facts here, the Commonwealth would say that this is not a Palmer situation. This is not like the cases my brother cites, where you have numerous officers converging on one individual who doesn't want to speak with them contrary to their intent and runs and they pursue. Here, Lieutenant Capasso sees the defendant do something very odd, which is get out of the car and toss a bunch of cash in the air. He follows him to see what's going to happen next, and then he makes an observation that gives him clearly reasonable suspicion. When combined with the defendant's presence in a car recently where a gun was seized, with the seizure of another gun from an individual in the group by the loading dock, when combined with the nature of the area, given the hot spot due to gang activity and recent shots fired, that clearly gives him reasonable suspicion for further pursuit. And I would say that's the point at which the defendant is seized, and that's an appropriate moment for him to be seized because the officers have reasonable suspicion. I don't know if the courts have any questions. If not, at this point, the Commonwealth will be content to rest on its brief and cede the rest of its time, asking you to affirm the denial of the motion to suppress.
I see no questions. Thank you both.
Thank you, Your Honors.
Well argued. The case is submitted. At this point, we'll take our morning break, which will last for 15 minutes, and we will see you afterward.
Hold on, rise, please. Court is now in session. Please be seated.
Good afternoon, everybody. Welcome back. We are moving into the civil part of our docket for today. So the first civil case is 24P1000, trustees of 549, 551 Boylston Street Condominium Trust versus Walter Chamberlain and others. Counsel, whenever you're ready.
Your Honor, I believe it's still good morning, so good morning to the panel. My name is Michael, if it please the court, my name is Michael Magger, and I represent the appellant, 549 to 551 Boylston Street Condominium Trust. Your Honors, there are two fundamental premises now before this court. The first one is the unit owner is not challenging the assessment made by the condominium trust and never has. The second fundamental premise is that the unit owner acknowledges that it is responsible for 8% of that assessment. The court need not take my word on that. In its brief, the unit owner tells this court that the latter is the, quote, single issue, end quote, presented, and that, quote, the Unit 201 owner's position is that the trustee's defense costs in the 2010 civil action is a common expense of the condominium and as such may be assessed with all the common expenses against Unit 201, but only for the Unit 201 owner's 8% proportionate share as provided for in the master deed and the declaration of trust. I can give the court about 6 more examples of similar language that are throughout all aspects of the appellee's brief.
I just don't know how that helps you. I mean, so they agree that they owe 8%, but you're trying to get a lot more. So how does that help you?
Well, it helps me, Your Honor, beginning with the fact that clearly the unit owner is not challenging the assessment. It helps me, Your Honor, because if you look at 183A, Section 6A, Roman numeral 1, and 6A, Roman numeral 2, and you look at the scheme of the 2 parts of 6A, 6A, Roman numeral 1, Your Honor, deals with the assessments that would take place on an annual basis. It's consistent with 5.4.2 of the condominium trust, which the unit owner in the appeal, in defense of the appeal, primarily relies exclusively on that section 5.4.2. So when you look at 5.4.2, again, commensurate with 6A1, Roman numeral 1.
Just before you continue, I'm not sure it is commensurate. I mean, 6A requires that a unit owner fail to abide by the requirements of the master deed, trust bylaw, or engage in other misconduct.
So now, Your Honor, you're referring to 6A Roman numeral 2. With 6A Roman numeral 2, to skip ahead and answer your question, Your Honor, 6A Roman numeral 2 deals with the situation where, unlike 1, which is dealing with a proportionate assessment against all unit owners, 6A Roman numeral 2 deals with the situation where the condominium wants to make an assessment against a single unit owner. The language you just mentioned, Your Honor, is exactly the criteria that's applied and whether the assessment is applicable under 6A2. The statute begins with the language that if there's a violation of the chapter, if there's a violation of a master deed, a condominium trust, rules and regulations, or bylaws, or if there's misconduct. We're beyond that, though, Your Honor, in this case, and as Justice Hershfang asked me, how does that help me? It helps me, Your Honor, because, again, we're beyond the factors that the court would consider if the unit owner was challenging the assessment. We're beyond that. The unit owner is not challenging the assessment, Your Honors. They haven't challenged the assessment. They do make a misconduct argument at some point in their brief, but the misconduct argument is moot because the misconduct argument would come up in actually qualifying or quantifying the assessment itself and whether the assessment itself is proper under 6A2. So I hope that answers both of your questions, Your Honors, that
It doesn't really. I mean, I'm trying to follow your argument, and I think I may have figured it out, but so I'm going to try, and you tell me if this is right. Is your position that by failing to challenge the assessment, the defendants are agreeing that they have failed to abide by the requirements of the chapter or the master deed trust bylaws, restrictions, et cetera, under 6A2?
Your Honor, I believe you can say it that way, but I don't think that's the issue. I think that to answer your question with a better question, in answering your question, though, is that what's happened here, Your Honor, is that the defendants have never challenged the underlying assessment. They've never said,
Okay, but wait, I'm not sure I'm following you on the underlying assessment, so let me tell you what I understand about this case. There was a lawsuit. It went on forever. It cost a fair amount of money in legal fees. The legal fees, whatever that number is, 90-something, were to be apportioned among the unit owners, because that's how the condo docs work, right? So in my mind, the assessment is the total amount of the legal fees. Are you talking about something different when you talk about the assessment?
I believe so, Your Honor. I think you're talking about a 6A Roman numeral 1 or a 5.4.2 assessment that's done based on the upcoming fiscal year. You're talking about an assessment, for example, Your Honor, where you look at property management fees, insurance, accounting, landscaping or snow removal, water, electricity for the condominium. Those are regular recurring fees that come under 6A1, 5.4.2 of the condominium trust. What we're talking about here, Your Honor, is an assessment that was made against a specific unit owner under 6A Roman numeral 2, because it was only that unit owner that was responsible for the condominium incurring those fees.
Well, that's your position, that only that unit owner was responsible, and that, therefore, the unit owner is responsible for those fees. But your brother does not agree with that.
Your Honor, I don't know how my brother cannot agree with that, because, again, my brother is acknowledging or has never challenged the assessment. So my brother has to be agreeing with that.
Isn't that why we're here? Because he's challenging the assessment?
No, Your Honor. We're here on the, and again, as I started my presentation, Your Honor, the unit owner himself says that we're here, he tells the court that we're here on, quote, on the, quote, single issue presented. That single issue presented, Your Honor, is whether the condominium can assess the unit owner at 8% or 100%. That's the single issue that they present. Now, Your Honor, they do, I guess maybe where you're going, if I can guess, is and you asked about the misconduct issue. The unit owner does bring up misconduct. They bring it up later in their brief, but when they bring up misconduct, first of all, Your Honor, they're bringing up misconduct, whatever metaphor you want to use. The horse has left the barn, the cat's out of the bag. When they're arguing misconduct, misconduct goes to the underlying assessment itself, and whether the underlying assessment is a proper assessment pursuant to 6A Roman numeral 2. Again, I submit to the court, we're beyond that, because the unit owner is saying, yes, we agree with the assessment, we're not challenging the assessment, but we're saying we only owe 8% of it. So that then brings up the question, so what's the misconduct argument in the unit owner's brief? The misconduct argument in the unit owner's brief is that misconduct applies, or misconduct, there was no misconduct, and therefore because there was no misconduct, we can't charge you more than the 8% of the assessment that we agree is a proper assessment. But however, again, the misconduct argument made there is too late. If you're making the misconduct argument, as Counsel Smith asked me, if you're making the argument about under 6A2, did it violate the chapter, did it violate the master deed or the condominium trust? Those are all questions that go to the underlying assessment itself, and is the assessment a proper assessment under 6A2? That's not a question that the defendant, that the unit owner put before the court. If it was, Your Honor,
Your burden. It is your burden when you're trying to get all of the money from one of the unit owners, and the condo docs say that the money is split among all the unit owners. My understanding of 6A2 is that if you're looking to assess 100% of the cost to one guy, you need to show the violations that are listed in 6A2. Is there some other thing, whether it be a condo provision or Massachusetts law, that allows you, your client, to to assess 100% of the cost to one unit owner?
So, Your Honor, that question gets into the question that the Superior Court judge asked in reaching the summary judgment decision, where I think the Superior Court judge made an error. You're asking me, Your Honor, to answer a question that's never been put before the court, and it wasn't put before the Superior Court. Why should the plaintiff be in a position to address something or answer a question that the unit owner did not see fit to put before the court? And again, Your Honor, all the unit owner put before the Superior Court and all that the unit owner is arguing before you today is that we're only responsible for 8% of the assessment. Therefore, Your Honor, the assessment is the assessment. The underlying grounds for the assessment is irrelevant because the unit owner is not challenging the assessment. If the unit owner had challenged the assessment in Superior Court, we wouldn't be here today, Your Honor, because there would be material issues of fact. And
So if they pay 8%, you're happy?
no, Your Honor, because they were assessed under 6A Roman numeral 2, and under 6A Roman numeral 2, where they've acknowledged the assessment, where they admit the assessment, they owe 100% of that assessment, Your Honor.
Why?
Because under Roman numeral 6, so under Roman numeral 6A2, Your Honor, as I explained a few minutes ago, that starts with what qualifies under 6A2. And what qualifies under 6A2, Your Honor, is where you have a charge that emanates from a breach of, or from a violation of the chapter, from a violation of condo docs, the master deed, condominium trust, or where there's misconduct. That's where it emanates from. I would submit to the court that was an issue that's never come up in this litigation, Your Honor, and especially didn't come up in the summary judgment argument because, again, all the unit owner has argued is that we only owe 8% of the assessment. You can't argue that you only owe 8% of something if you're not acknowledging the underlying assessment, and that's what they're doing. So your question, Your Honor...
Or are you disclaiming in your effort, in your client's effort to get 100% of the assessment from the defendant, are you disclaiming reliance on Chapter 183A, Section 6A2?
Absolutely not, Your Honor. I'm actually applying Section 6A2.
So now we're talking about 6A2. And 6A2 allows exclusive assessment of an expense against one unit owner in a case where the expense is incurred, and now I am reading from the statute, as a result of the unit owner's failure to abide by the requirements of this chapter or the requirements of the master deed, trust, bylaws, restrictions, rules, or regulations, or by the misconduct of any unit owner. So which of those things did the defendant do here that allows you to assess 100% of the cost against the unit owner?
So to answer that question, Your Honor, the unit owner has argued to this court and argued to the Superior Court. They only argued the misconduct issue.
No, I want to talk about your proof, not what they've argued. Don't spend your time talking about their argument. I want to hear your argument from you. Why do you get 100% of the funds from them? What did they do?
So what happened here in the 2010 litigation, Your Honor, the 2010 litigation consisted of 19 counts that were brought against the condominium. There were 8 counts that were successful, and 5 of those counts were derivative counts. What gives us, I believe, the right under 6A2, what gives us the right to bring the original complaint, Your Honor, under 6A Roman numeral 2, was that the counts that the unit owner were unsuccessful on were counts where the condominium trust had followed both the master deed and the condominium trust as they were required to follow. Therefore, bringing that action was contrary to what the condo trust and the master deed said. Therefore, it unnecessarily caused the condominium to incur expenses that it otherwise shouldn't have incurred. And as a result of that, Your Honor, that's where we come under, that's where the initial complaint was brought under 6A Roman numeral 2. However, with that argument made, Your Honor, again, I can give you seven different examples, Your Honor, throughout the appellee brief where they say over and over again, we're not contesting.
Yeah, but you know what? This sounds a lot like your abuse of process claim from 2010 that was rejected.
Your Honor, yes, the abusive process claim was rejected. I think.
So aren't you just kind of relitigating this?
Absolutely not, Your Honor, because this goes beyond. This goes beyond that issue of the abusive process claim. This goes to an actual trial, an actual finding that would have been made again, where the unit owner was only successful on 8 of 19 total claims. To that end, Your Honor, I would also submit to the court that if the court looks in the record, there's an argument in the appellee's brief about misconduct and about that they were successful on these claims, and therefore, because it was successful, it's not misconduct. I think going to your comment you just made, Your Honor, I direct the court to the appendix, page 225, where the trial judge in the 2010 action, who was considering a motion for attorney's fees for about $69,000, he says, quote, "The court also agrees with the defendants that the request is disproportionate to the size of the recovery. This is essentially a claim that the, quote, results obtained warranted the level of effort." Case citation. "The court must make a very significant downward adjustment because of the plaintiff's very limited success. Allocating the effort for the work expended on the derivative claims alone already accounts for this factor without further adjustment, except to account for the partial success on the exhaust vent claim." So I think that's a direct comment, Your Honor, to the comment you just made to me.
Well, but just a few pages before that, though, when the judge rejected your counterclaim, you specifically said that the unit owners did not act for an ulterior or illegitimate purpose, and he declined to remove the trustees from their positions. He said it was a close issue. So it just strikes me in reading all of this, and again, this goes back to 2010, which is quite remarkable, that 15 years later we're still talking about it, it seems to be the approach that your client seems to be taking is, okay, well, you may have prevailed in the litigation against us, but we're going to fix your wagon, and we're going to just go for the attorney's fees, and we're going to recoup whatever we lost. It seems pretty vindictive.
Having lived through the 2010 case myself, I can address that today, even today, after all these years.
Address it briefly, please, counsel, because you're a minute and a half over.
Okay. So, Your Honor, to address that point, the other factors that I believe allowed us to assess this under 6A2, the 2010 case was brought initially for claims, for individual claims that the unit owner had. I pursued for approximately 3 years a defense that the case had to be brought on a derivative basis. It took approximately 3 years to get before a Superior Court judge, before a Superior Court judge said to the other counsel, "Sir, isn't this a derivative case?" And the other counsel says, "Well, yeah, probably I should have brought it as that." And the judge allowed him to amend the complaint. After 3 attempts to amend the complaint was finally allowed to be amended. So that's just one factor, Your Honor, as to why or what justifies misconduct, for example, that the unit owner's attorney basically acknowledged to the court that he knew that this case should have been brought originally as a derivative action, yet he brought it as an individual action. Further, Your Honor, throughout that 3-year period, I filed a motion to dismiss.
Okay, I think we're a little outside the record here, so we'll have to leave it there. Thank you very much, counsel.
Thank you.
Whenever you're ready, counsel.
May it please the court, my name is Samuel Bolsey for the appellees, Walter Chamberlain and Yin Kauho, the owners of Unit 201 in the condominium. This court just zeroed in on the house of cards that the trustees' entire appeal is built upon, which is this misconception that by somehow the unit owners acknowledging that incurring legal fees is a common expense that condominiums may incur, that somehow is equated to a concession that then those assessments may be assessed entirely against Unit 201. That's never been their position, and that was the whole debate at the Superior Court. In fact, the Unit 201 owner's argument is actually very simple. Legal fees can be incurred by condominiums. It happens all the time. Those are common expenses, and common expenses under condominium documents, standard condominium documents, and Chapter 183A are then apportioned among the unit owners in accordance with their beneficial interests that are ordinarily spelled out in a master deed. And that's exactly what happened here. and that's why their position is that they are only responsible for 8% of this common expense. This court should affirm the decision of Superior Court for the three following reasons. First, the Unit 201 owners did contest the applicability of Chapter 183A, Section 6A, subparagraph II. Second, the trustees themselves concede that they do not have authority under the condominium documents to assess 100% of the fees against the unit owners. And third, not only do they not say so anywhere in their brief, but the Unit 201 owners also did not commit any violations of condominium documents or otherwise commit misconduct under Chapter 183A. Your Honors, first, of course, the unit owners contested the applicability of Chapter 183A, Section 6. This case was decided on cross motions for summary judgment, so that is where the dispute is. And if Your Honors just look in the record appendix between pages 194 and 196, Your Honors will find the unit owners' opposition and memorandum in support of their own cross motion for summary judgment. In the span of those 3 pages, we make the following arguments. First, that the unit owners did not violate any provision of the master deed or the declaration of trust or any rules and regulations of the condominium. And second, we go in length as to why the unit owners did not commit any misconduct, for however that term is interpreted under Chapter 183A, by filing and succeeding in large part in that 2010 civil action that made specific findings as to the misconduct of the trustees of the condominium. Trustees concede in their brief that there's no authority under the condominium documents to have made a 100% assessment of their defense costs against these unit owners. They do this in 2 places. On page 34 of the appellant brief, they specifically state, in order to determine whether such an assessment can be made and the manner in which it is to be treated, one must look exclusively to Chapter 183A, Section 6, subparagraph A, subparagraph II. And then on page 39, they're even more specific. The condominium trust, referring to the declaration of trust, does not expressly provide for the subject assessment. And then that brings us to a third argument, which is, if we are even to look at Chapter 183A, Section 6, the Unit 201 owners did not engage in misconduct or otherwise violate that statute, warranting an assessment of 100% of their legal fees. Frankly, the fact that the condominium trustees point to no violation of the condominium documents in support of the assessment actually should end the inquiry. In our brief, we cite to a case, it's Trustees of Hunters Village Condominium Trust versus Gerke. I'll acknowledge that that's a Rule 23 decision, it's not binding, but it is persuasive. And it says that misconduct relates to and is limited to a violation of Chapter 183A and or condominium documents and or rules and regulations of the condominium. We've attached a copy of that in our addendum at page 77. And in that case, it is the first attempt and the only attempt I've seen that defines this term misconduct, and still that term of misconduct is always in the context of whether there are violations of the master deed. There are alleged violations of Chapter 183A. There are violations of the declaration of trust or rules and regulations. Nowhere in their brief and nowhere in the Superior Court record do the trustees point to any provision of 183A or the declaration of trust or the master deed that has been violated by the owners of Unit 201. They rely solely on the fact that the Unit 201 won most, but not all of their claims in the 2010 civil action. But even if we look at the term misconduct more broadly than being related to the condominium documents, it just cannot be that winning most but not all of your claims in that 2010 civil action somehow amounts to misconduct. It just sets too low of a bar. To Justice Hodgens' important point about the findings on the abusive process and malicious prosecution claim, one way this court should look at this is that the Superior Court has actually already made findings that by bringing that 2010 civil action, the Unit 201 owners did not engage in any misconduct. And I'll quote directly from Judge Wilkins' decision. He said, "Here, Chamberlain did not act for an ulterior or illegitimate purpose. Rather, he sued to obtain compensation, declarations, and other relief for wrongs that he reasonably believed he had suffered or that the trust had suffered at the hands of the defendants. That is entirely his right and in no sense ulterior or illegitimate. The court has found above in favor of the plaintiff on numerous points. Moreover, there was probable cause and the plaintiff lacked malice. The judge went on to award the Unit 201 owners $12,500 in legal fees. The trustees came to this court on appeal. The Superior Court judgment was affirmed in favor of the Unit 201 owners. This court awarded them upwards of $7,000 in their appellate attorney's fees. And at no point did the trustees file a Chapter 231, Section 6F motion if they really believed that the claims in the Superior Court were frivolous. If that's misconduct, that just creates really bad public policy for condominiums everywhere, because in instances, such as here, by the way, where 92% of the condominium is controlled by a single family, those unit owners better be sure they're going to win on every claim, otherwise they may not ever pursue the opportunity to vindicate their rights under the declaration of trust or the master deed. It also creates a marketability issue for unit owners. If a condominium trustee or board decides they can assess, without pointing to any provision anywhere, an ability to assess a single unit owner for a common expense of the entire building that is outside of what specific statutes or specific condominium documents provide. And therefore, Your Honors, we would posit that the Unit 201 owners did not engage in any misconduct, they did not violate any condominium documents, and the decision of the Superior Court should be affirmed.
Counsel, apart from the misconduct or the 6A2 question, I think, and I might be mistaken, but I think counsel was arguing in the brief at 34 and also today that potentially this assessment is not properly under Trust Section 5.42. I would note in that section that the only time it refers to attorney fees is when it's talking about collection or lien. But can you speak to whether attorney's fees are properly or were properly envisioned or are properly part of 5.42?
In 5.4.2, the Declaration of Trust speaks to how common expenses are to be apportioned. And where we do agree with the trustees is that the incurring of legal fees by a condominium trust are common expenses, just as doing facade work or a roof replacement project or hiring an accountant. Now, in 5.4.2, it gives one specific example where 100% of the fees could be assessed against a unit owner. And that is only in the context where a unit owner has not paid the assessment and the condominium needs to bring a collection action to pursue the assessment. And actually, they have that same right under Chapter 183A as well in Section 6, even if the condominium documents did not provide for it.
So your position is they're conceding that attorney's fees are properly assessed under 5.4.2?
Yes, Your Honor, and under 5.4.2, it speaks very clearly that they're to be assessed in accordance with the beneficial interests of each condominium unit owner. And quickly to the other point that opposing counsel made, which is, oh, well, this is about the forward-looking budgeting process, and it looks at, what are the typical expenses that are incurred by condominiums. 5.4.2 is much broader than that, because then it continues, in the event that trustees shall determine during any fiscal year that the assessment so made is less than the common expenses actually incurred. So now we're looking at expenses incurred in real time. The trustees shall make a supplemental assessment or assessments and render statements, therefore, in the manner aforesaid, referring back to the comment about splitting up fees in accordance with beneficial interest, and such statements shall be payable and take effect, again, as aforesaid. And Your Honors will find that provision on page 90 of the record appendix.
See no further questions. If you have nothing else to say to us, the case will be submitted.
Nothing further. Thank you, Your Honors.
Okay, thank you both. Next up, Daniel Berg and others versus Commonwealth of Massachusetts, 2024 P 1287. Whenever you're ready, counsel.
So good morning, Your Honors. My name is James Heichel. I'm here representing IAFF Local S29 and Daniel Berg, the appellants. There's two questions that bring us before this court. The first is the one that the district court ruled on, which is whether or not we should be compelled to arbitrate these claims under the collective bargaining agreement. I present to you that the district court erred principally in ignoring the fact that the collective bargaining agreement, in effect at the time that this action was brought, codified an older version of of Section 59 before the Brave Act was passed. That is alluded to in the facts section of the district court's opinion, but it is not addressed in any way in the actual analysis or discussion of the claims. The reason why this is important is the very genesis of this dispute to begin with, which is when Daniel Berg realized that the Brave Act entitled him to greater benefits than what the collective bargaining agreement allowed, he contacted Marcia Hyatt, who was representative of the defendant military division, and said, how is this going to work? Codified in her email is an explanation of how he would receive benefits that has no relationship to the collective bargaining agreement. It is her own interpretation of the Brave Act as it applied, which is 40 days, as opposed to the 34 in the state fiscal year or 17 in the federal. And even though the district court says that day was not defined in the collective bargaining agreement, that is actually incorrect. Day was defined in the collective bargaining agreement. If you look at Section 6, subsection B, it says
Do you have a cite for that, a record appendix site?
Sure, it's the record appendix 71, page 71.
Thank you.
It says that within the collective bargaining agreement, 34 days, parentheses, 285.7 hours, or in any state fiscal year not exceeding 17 days, or in parentheses, 142.8 hours. These numbers are in effect, are actually 8.4 hours per day, which is the 1/5 of a 42-hour work week. That is the work week worked at the time by S28 members, which was the principal bargaining unit under which this collective bargaining agreement was originally negotiated. But ultimately, day was defined as 1/5 of a work week. When the Brave Act was passed is when the dispute arose.
I know that was in 2018, but I didn't see a specific date in the record. Do you know when in 2018 the Brave Act was passed?
August of 2018.
Thank you.
So when the defendant unions reached out to the Commonwealth to ask, and this kind of gets to don't lose the forest for the trees argument that I'd like to make, obviously arbitration is a creature of contract. It only exists if the parties agree that arbitration exists and only applies to those things that they agree it should apply to. In this case, defendant unions reached out to the Commonwealth and said, we don't see where the Brave Act fits into the current construction of our collective bargaining agreement. If you'll agree that the Brave Act can be litigated, we'll go to grievance arbitration. That's where I do 90% of my work. I'll happily go to grievance arbitration. They would not agree. With the definition of military leave in the collective bargaining agreement as specifically codified of the prior version of the law, there was no way an arbitrator was going to be able to invalidate that. It's a specific prohibition in the collective bargaining agreement. The arbitrator cannot subtract to, add to, or modify any specific term in the agreement, and that's at Record Appendix 102. So ultimately, either the parties were going to agree they could apply the Brave Act as a statute, or I would have to come to court and file a claim there, which I did. We then engaged in collective bargaining, where the parties once again acknowledged that the old version of the law was in the collective bargaining agreement. There was no way the Brave Act could be administered under the current structure of the collective bargaining agreement. At that negotiation, we once again agreed to eliminate all of that language to allow this action, specifically this case was discussed at collective bargaining, and it was decided we would allow this case to determine what the military leave benefits would be. We put essentially a placeholder in the collective bargaining agreement that said, whatever the law is, that is what members will get. Only after that agreement came did we see a motion for judgment on the pleadings that contained an allegation that all of this needed to be arbitrated from the outset 3 years earlier.
So I understand, and I sorry to cut you off, but time is already fleeting, and I think there's a lot to talk about in this case, and I want to make sure we get there. I understand that you feel that you have been very ill-used by the Commonwealth in the run-up to this case, and having looked at the records, I can't really disagree with you. But I do want to focus pretty precisely, at least as a first question, on the issue of incorporation. And because I think, and tell me if you disagree with me, that the question of whether this is a grievance under the collective bargaining agreement really turns on whether or not the agreement incorporated the military leave provisions, or didn't. Am I right so far?
You are right so far, but
Okay.
I do want to add some nuance to that, which I
Okay.
think the district court ignored. So if you look at the Rooney case, specifically footnote 4, and kind of their analysis of whether or not Section 108L...
Or not two?
What's that?
Not two? Go
Well, it's
ahead.
both 2 and 4.
Okay.
I'll talk about both.
Okay.
So in footnote 2, it talks about that the collective bargaining agreement incorporated the statute as amended here or in the future, which does not exist in this collective bargaining agreement. It does say that it's incorporating the statute as amended, but not in the future.
It also says, just because I want everything in your mind at this one moment, in section 6, subsection F, this section shall be construed in conjunction with applicable law.
Correct.
So I want you to address that too, please.
Yes, and that's also in this collective bargaining agreement at the end of the military
That's the
leave
one I
section.
meant, yeah.
Right, shall be construed in consistent with applicable law. I think the biggest distinction between the collective bargaining agreement in Rooney and in this case is this collective bargaining agreement went the extra mile. It defined what it included 34 days, 17 days, days equals this. Whereas the Rooney court was not so constrained. It just had this section of the law go apply the law, which is, by the way, why when we amended the collective bargaining agreement here in 2023, we made it much broader, so we would not be in this position again.
2021,
No, that's,
right?
no.
Or you're not talking about the MOU from 2021?
I think it's later than 2021, but I'll defer to whatever the record is when we amended, because this collective bargaining agreement expired in 2021.
20. Okay.
Well, there was an extension of it. I apologize. I should be more up on these.
No,
facts,
no,
but
that's all right.
whenever-
I really want to make sure I'm getting the dates right, because I think it matters for your clients a lot, right? I mean, one of your clients served as a firefighter and in the military during a time period that was covered only by the old collective bargaining agreement. The other one, I believe, continues to serve through the time that's covered by what the Commonwealth calls the MOU and you call something else, which confuses me, but
The
the new
MOU.
thing.
We'll call it the MOU to be consistent. And I do also want to clarify one point that you're raising, which is there were two individual clients in this case, Daniel Berg, who is a member of Local S29, and Andrew Ferreira, who is a member of Local S28. I didn't see it, and I know that since this case was initiated, Local S28 switched counsel, and they have withdrawn from this appeal.
Oh.
So Andrew Ferreira and S28 are not here before you today. I'm here only representing S29 and
Thank
Daniel
you.
Berg, who only was active into 2020. He did not extend it to 2021. But I do actually want to address that point in any event. But sorry, I've lost my train of thought. So going back to what was incorporated into the collective bargaining agreement, if it had just been straight, we adopt the law as amended, even without this whole future phrase that's in the Rooney collective bargaining agreement, I think there would have been a stronger argument that it should have been subsumed in arbitration, that there is at least an anticipation that it could be amended and it could be arbitrated. Where the collective bargaining agreement, however, was very specific about its terms, it was clearly locking in the benefits at that time, which is not the case in Rooney. And this gets into the Section 150E Section 7D argument, which is there's some issues that are just not allowed to be collectively bargained. It was addressed in Rooney as well as in the Willis case that said you can codify rights into a collective bargaining agreement as long as there's no conflict. If there's a conflict, it's out. So to the extent in Rooney as well as Willis, there was no conflict, you could apply it as written. Here that is not the case. When the BRAVE Act was passed in 2018, now the collective bargaining agreement's provisions are in conflict with the law. It is therefore null under Section 7D of the collective bargaining statute, Section 150E. And that is in footnote 4 of Rooney, which is what I was alluding to earlier, which is this idea of a conflict, that you can't have a conflict. So once that conflict existed is why the unions reached out to the Commonwealth, said, you know, we can arbitrate this, or we can, holding aside whether I feel abused, I think the fundamental legal question is whether or not this is actually ripe for arbitration.
And how do you deal with, or if you have a case, I would love to know about it, that addresses in the context of arbitration, because there are all of these, as you know, and you've cited, all of these cases, federal and state, pro-arbitration. Basically, if the parties have it in their agreement, we need to defer, and the Superior Court judge acknowledged this as well. There's sort of a presumption of arbitrability, right? But then there are also cases, and I don't think either of you cited them, but there is a case, 377 Mass 392 School Committee of Brockton versus MCAD. I may have the wrong case. I may be talking about the wrong case. That say, well, if you put the words of the statute in there, or you don't say specifically that you are incorporating it as amended, the way Rooney did here now and in the future, that you aren't actually incorporating the statute and it stands alone. So here, in this case, I think one could see a tension between the fact that the CBA articulates word by word the old statute, but nonetheless then has that section at the end, 6F, that says something about following it according to the law, right? This section shall be construed in conjunction with applicable law. I feel like there is a really poorly articulated by me tension there between the pro-arbitrability presumption, the construed in conjunction with applicable law, which one could argue, perhaps your brother will, sweeps in whatever the current version of military leave is. That's on one side of the ledger. On the other side of the ledger is sections 6A and 6B that articulate something that is actually, by August of 2018, inconsistent with the governing law.
Right, and I think my brother would also, I think 6B and 6C are the things that are very much in conflict with governing law by the time 2021 rolls around. I think 6A actually is something my brother might refer to as supporting his argument insofar as it says, entitled to time during service in the armed forces consistent with the law. I think the problem that we run into is, let's say we went to arbitration. Let me put it this way, hypothetically. Let's say I had gone to arbitration in 2021 under this collective bargaining agreement that existed at the time. The arbitrator is constrained to both apply the law and enforce the specific terms of this agreement. The only plausible conclusion that arbitrator can reach is that the law that they must construe this consistently with is the law that existed at the time. There is no other way to put these two provisions together in a way that's logical or rational.
At the time the CBA came into effect.
Correct. Or in the time that the arbitrator is deciding it in 2021, because that is the only agreement that exists at that time. Now, if after the agreement was amended, we once again brought a case at that point, maybe we would have a different argument. But at the time this agreement, at the time the unions are reaching out to the Commonwealth in 2021 before this action is filed, no, that's the only way that those two, the arbitrator can remain loyal to their obligation to both apply the terms as written and apply it consistent with the law is only with pre-Brave Act law. That's the only way it could work, which means, therefore, that the right we are here enforcing is purely a statutory right. It is not a collective bargaining right. It is not codified in our collective bargaining agreement. It cannot be enforced in the collective bargaining agreement. It can only be enforced as a statutory right in the Superior Court. That's why we're asking to go back. I'm just going to briefly move to one point that I also want to make. These justices might also be aware that there's a companion case pending before this court right now, Driscoll versus the City of Melrose. The Commonwealth has yet to address the merits of what Section 59 means in the context of this case. It was solicited by the court to submit an amicus curiae brief in that case. And so to the extent that this court should reach the issue of what 59 means, okay, I would just defer to their arguments in that case in which they articulate as I do that day should mean any 24-hour shift that Commonwealth firefighters work.
But if we found for you that, or agreed with you that the matter shouldn't go to arbitration, belongs in a court, would it be more proper to remand it or to decide on the merits?
I think there's sufficient information before this court to decide on the merits. We know how the Commonwealth is applying the military leave statute. Marcia Hyatt's email is in evidence. There's never been any dispute that that's the way they're applying it. So the question is whether or not day as 10.6 hours is consistent with the statute or a violation of the statute. And that's something that this court has plenty of information to make.
I just have one question. What, isn't it kind of putting the cart before the horse, anticipating what law an arbitrator would apply? I mean, don't you have to go the grievance route first and see where that takes you? I mean, it seems like we're anticipating a number of steps ahead as to what might happen, but, I mean, isn't that the nature of having the collective bargaining agreement, that you have to follow it? And without sort of making guesses as to how things might come out?
Typically, yes, but not in this case. And the reason is, when we are filing for arbitration, and it's spelled out in the grievance arbitration article itself, we have to allege a specific violation of a provision of this agreement. Without question, the arbitrator's role, I mean, even if they incorporate a statute, they have to apply the agreement. And in this case, we know the number of days and the number of hours are spelled out specifically in this contract. What we would be asking the arbitrator to do is apply a statute separate from the CBA that's in conflict with what is written in this agreement. We know that that's what we would be asking the arbitrator to do. So no, I don't think we need to go to the arbitrator to say, you have a choice between either applying a law that is potentially incorporated or potentially not, or applying the clear language, because we know the arbitrator's primary role is to interpret the collective bargaining agreement itself.
Thank you very much.
Thank you.
Whenever you're ready, counsel.
Thank you, Your Honor, and may it please the Court, Gerard Cedrone from the Massachusetts Attorney General's Office on behalf of the defendants. The Superior Court correctly dismissed the plaintiff's complaint and ordered the parties to follow the grievance procedure outlined in the CBA. At its core, plaintiff's claim is a claim about the calculation of leave time as a state employee. That's a quintessential subject of collective bargaining, and it's well within the scope of the CBA here. I'd like to start by discussing the language of the arbitration provision and then address the principal arguments that my colleague on the other side made. So first, the arbitration provision. It's in Article 23A of the collective bargaining agreement at pages 100 to 103 of the record appendix. And it says, the term grievance shall mean any dispute concerning the application or interpretation of the terms of this collective bargaining agreement. That's a very broad provision. And so then we look at Article 8, Section 6, to understand whether military leave is, in the language of the arbitration clause, a dispute concerning the application or interpretation of the terms of the agreement. And it is. So Section 6, subsection A, is, and I'm talking now about the initial collective bargaining agreement, and that was in force from January 1st, 2018 to December 31st, 2020. That's at page 108 of the record appendix. That subsection A of Section 6 is just a straight cross-reference to Section 59 of Chapter 33 of the General Laws.
Well, I'm not sure that I agree with you that it's a straight cross-reference. I mean, if we look at subsections, Section 6, subsections A, B, and C, each does refer to Section 59, but subsections B and C do more than refer. They actually articulate what was at the time the text of Section 59, which from your perspective is rather unfortunate. I mean, if they had simply said, as they did in Rooney, it's incorporated as amended and as amended in the future, I would be much more inclined to agree with you that the interpretation of this provision of the CBA is within the arbitration clause of the CBA. But instead, somebody got fancy and wrote out exactly what it was the law said at the time. So why, in the circumstance where what is written, that's a horrible sentence. I'm going to start it all over again. Would you agree with me that what is written on page 71 of the record appendix in subsections B and C of Section 6 is inconsistent with the Brave Act?
Yes, I think if you were looking at those, just to be precise, if you're looking at those in isolation, yes, I think there's a...
I'm looking at them in the CBA, so I don't know if it's isolation. I've got all kinds of other stuff here on my iPad. But So now we have something that's inconsistent with the law. Now, Section 6 also has subsection F, which says this section shall be construed in conjunction with applicable law. I'd love to know your thoughts about that, but not yet because I'm still talking, except I forgot where I was going. So if subsections B and C articulate military leave rights that are inconsistent with the law of the Commonwealth, how is it that subsections B and C, that a violation of, or, an enforcement of something pursuant to subsections B and C is arbitrable?
So I have a couple of answers. I think 3 points that I would make. One is that, as I understand the record, Mr. Berg was a member of the National Guard, not the reserves. There's two components of the military that often get lumped together, but there's the National Guard, which is a state force, and the Armed Forces Reserve, which is a federal force. Subsections B and C apply only to the reserve components of the Armed Forces of the United States. So to the extent Mr. Berg is seeking leave under this provision, it's only under subsection A. Subsections B and C don't apply to him, and there's no other plaintiff in the case anymore. The second response, I think, is subsection F of Section 6, which says this shall be construed in accordance with applicable law. I would understand that as a saving clause. To the extent there's some sort of conflict with applicable law or some sort of tension between the two, incongruity between the two, you're supposed to read this provision to harmonize with applicable law. And then the third point I would make as an overarching point is that these kinds of questions, even if there's some doubt about that, how does this provision fit with that? How do you understand these these provisions that are seemingly in tension with each other? That's a question for the arbitrator. Arbitrators answer those kinds of questions all day, every day. How do we understand this contract in light of other provisions in the same contract, in light of provisions of governing law? And if governing law is to the contrary, how do we harmonize the contract with governing law? Those are the types of questions that arbitrators answer every day. The fundamental question for purposes of deciding whether to send it to arbitration is whether the parties manifested an intent that military leave and the application of Section 59 be part of the agreement itself rather than something freestanding. And that, I think it's difficult to come away from this provision, even with these complex questions, with the conclusion that they did not intend to fold this into the agreement.
I think that agreeing with you on that requires two assumptions. One, that when you're talking about this provision, you're talking only about 6A. And two, that the language of the CBA is adequate to sweep in any substantive future amendments to Section 59. Do you agree with me on both of those things?
I think that those are both premises of our position, but I believe that Section 6F is adequate to sweep in subsequent amendments, or at least to put it in the arbitrator's bailiwick to decide how these provisions reconcile with governing law.
So the thing that I was trying to find before and miscited is Mayor of Salem versus Warner Amex Cable Communications, 392 Mass 663, which is an SJC case from 1984 that says that where the future amendments are not specifically included in an agreement, we're not going to read in the party's intention to agree to future amendments. It says amendments enacted after execution are not incorporated, this is 666 to 67, into an agreement unless the contract provisions clearly establish that the parties intended to incorporate subsequent enactments into their agreement. I take it your position is that this CBA does clearly establish that the parties intended to incorporate subsequent enactments?
I think that's correct, both the combination of subsection A, which is a cross-reference to 59 and without added language about how to calculate anything, and then subsection F, which has language about construing in conjunction with applicable law. And I think that principle itself, the idea that you have to decide what intent did the parties manifest, I think that too is properly within the scope of the questions the arbitrator would consider. That kind of analysis of what does this contract say and what does it show about the parties' intent is the kind of question that arbitrators are used to dealing with, and the arbitrator might well decide against us on a particular question, but it's for the arbitrator.
Why are you so eager to go to arbitration? I mean, you filed a very elegant amicus brief in the Driscoll case, clearly expressing a view about the meaning of the Brave Act, and it's what is a day and what is 40 days requirement. What does the Commonwealth gain by doing that in arbitration when it's already doing something very similar in the courts of the Commonwealth?
So we are not a party to the other case. We filed a brief at the invitation of the court, but we have an agreed upon process for resolving these kinds of disputes between an employee and the Commonwealth. And so our position is that this is what both sides agreed to. And I guess that takes me to the next argument that my colleague on the other side raised, which was about the notion that the Commonwealth waived arbitration or conceded that this should go to court. That's not borne out by the record, and I'd like to be very clear about what's in the record. So the two things that I think my colleague on the other side points to, one is a set of emails at pages 161 to 162 of the record appendix. Plaintiff's counsel sent an email saying, we have this dispute, we're considering suing over it. Maybe we would grieve it if you would agree to grieve it, and there's just no response to the email. The agreement, the CBA is pretty clear. Article 23A, Section 11, that's at page 102 of the record appendix, says that the only way to waive the grievance process is by mutual agreement in writing. So an unanswered email isn't that. The only other piece of evidence in the record, as I understand it, is at pages 164 to 165. There's a declaration saying that the Commonwealth's collective bargaining agent said in a collective bargaining meeting, well, this issue is going to be resolved in court. That statement, even assuming you can consider this hearsay statement in a declaration, that was in September of 2021, so after the plaintiff filed the complaint in this case. So I don't think it's a waiver to say once the plaintiff has already gone to court for a representative of the Commonwealth to say, well, this is, you filed a complaint, this is going to be resolved in court. There is not the kind of mutual in-writing waiver that you would expect to see to waive the grievance process.
Yeah, I think I'm held up in an earlier point. I mean, you're arguing, and I might do the same if I were you, that all of this could properly be decided by an arbitrator. I don't know that there's anything in the record that says that an arbitrator is, unable to or unequal to the task of making these decisions. But I think the predecessor question is this a grievance under the CBA? And that question is going to revolve around a determination that I think may be made by the court. It probably could also be made by an arbitrator, but here we are, of whether the statute is incorporated as amended in the CBA. And what do you say to the argument that your brother makes that has a certain resonance in the record, that once the Brave Act is amended in August of 2018, there's then over 2 years where, for at least some employees, and I understand, luckily for your argument, I guess, we've lost the employee for whom this is more relevant, but portions of this CBA, 6B and C, are inconsistent with what would then be governing law for 2 years of the CBA.
I think in addition to the points that I've made before just about the language of the agreement and the fact that these are the kinds of things that an arbitrator is competent to address, I would mention two other points. One is that this case was dismissed at the pleading stage, so all we have are the plaintiff's allegations with some attachments and the appropriate denials to certain paragraphs. There is, I think, much more fact development to be done in any given case about what leave a particular individual took. Are they a member of the National Guard or the Reserves? If you look at Section 59 of the statute, there's a host of subsections dealing with certain specific types of deployment. So in the Driscoll case that we've been discussing, we filed an amicus brief answering an abstract legal question sort of in a vacuum almost. Obviously there was a case there, but we're not a party. We answered a strict legal question. But this issue needs to be decided in cases involving real people and real periods of leave that we just don't have on this record. So I think that's one reason why it's appropriate for these things to be resolved in arbitration exactly as the parties agreed. The other point I would make is I think it's footnote 14 of the Daluz case that we cite in our brief, walks through the ways that in that case the statute in question differed from the language of the agreement in question. And it specifically called out that for one type of absence, the statute said, I don't want to get it backwards, I think the statute said 8 days and the agreement said 6 days. That wasn't, it's just a footnote. It's not, the court didn't analyze that. But I think it's relevant that the SJC didn't see as an impediment that there was some daylight between what the statute calls for and what the agreement calls for, and nevertheless considered the agreement there to have incorporated the language of the statute. And I think it's...
But that wasn't at issue. That was a terrible sentence also. The SJC was not, was not asked in Duluth to decide whether the statute incorporated, whether the CBA incorporated the statute in the context of arbitrability, right? That was a case involving whether a prior decision was going to be binding.
I think in that portion of the opinion, the court was deciding whether the statutory right in question was freestanding and non-waivable, or whether it was something that was of the type that could be incorporated into the agreement. So I think it's at least relevant that there, in that case where that was at issue, and that's an argument that the plaintiff has made here, there was that daylight between the agreement and the statute. The final point I would make, plaintiffs have alluded to the merits. I think if the court disagrees with us on arbitrability, the correct course is to send the case back. I expect there will be a decision in Driscoll that sheds some light on the statute here, and that's best, the Superior Court is best positioned to address that in the first place. And then I would just close by saying, as Your Honor pointed out, there is a presumption of arbitrability. The SJC has quite clear language on this, that there needs to be positive assurance that a matter was intended not to go to arbitration. So even if Your Honors concluded that some of these questions were close, there is not the kind of positive assurance that this is inappropriate for arbitration. Unless Your Honors have further questions, we would ask the court to affirm.
I see none. Thank you both very much. The case is submitted. Our final case of the day is 24P1044, Michael Pascucci and another versus Town of Lynnfield and others. Good afternoon, counsel.
Good afternoon, Your Honor, members of the panel. My name is Michael Walsh. I represent the plaintiffs, Mr. and Mrs. Pascucci. This is a case arising out of a condominium on Partridge Lane in Lynnfield, which is subject to a 40B program. It is subject to a deed rider, which was the subject of an earlier Superior Court case that we have argued, among other things, is essentially void. The heart of our voidness argument, it turns on the idea that in the earlier case, the Pascuccis were at first represented by an attorney by the name of Santangelo. Subsequently, they ran out of money to pay him, and he withdrew, although it took some time for his withdrawal to be effected as reviewed on the earlier docket. Subsequently, the Pascuccis were defaulted by the Superior Court for failing to attend their depositionshowever, when Justice Lang issued the order defaulting the Pascuccis, he simply issued a default as to liability and left a question of the remedy for the default to be determined later in this earlier 2014 case. Among other things in particular, the entry specifically promised a later hearing. That was also discussed by the Superior Court in the earlier case in what is page 80 of my PDF submission. It's the appendix to my brief. The Superior Court judge recaps the fact that although the individual defendants have been defaulted, that there will be a later hearing. That later hearing never occurred. At one point later on, Mr. Pascucci did in fact show up, entirely pro se, as a high school graduate trying to keep track of some relatively complex real estate proceedings, and he said, "Your Honor, I'm here to be heard." And essentially, the bank's counsel and the town's counsel told him that this was a damage assessment hearing to deal with the attachment defendants, not his hearing, and he never got his hearing. We've argued.
But what about the motion to vacate, clarify the default? I mean, he got a hearing for that, didn't he?
Or
at least an opportunity to be heard.
That was done on the papers. There was no hearing about that.
But he had the opportunity.
not a sufficient opportunity to argue that was a discretionary motion that he made to try, pointing out about the earlier promise of a hearing and asking the court to grant him a hearing. And the Superior Court decided that they were not going to undo the default, but still did not hear him. Your Honor will recall that under Rule 54, there is even a defaulted defendant retains a strong interest in the right to be heard about the shape and the character, and not just be heard in the papers, but to actually be invited into the Superior Court and to make his argument in person.
But what do we do with that, where the judge said that the defendants have failed to demonstrate by affidavit or otherwise good cause for removal of the default for their failure to address the default? So it looks like the judge did consider.
Your Honor, that is because Mr. Pascucci did not attach an affidavit to his motion to withdraw the default or clarify or vacate the default in the earlier judgment. But the fact remains that even if he hadn't made that motion, even if he just stood as a defaulted defendant, for example, we cite the cases in our brief which also follow Rule 54 that say even if you don't answer, even if you don't show up, even if you don't respond, you're still entitled to that in-person hearing on damage assessment. You're still entitled to be heard on the shape and form of it. And that hearing never occurred when the judgment against Mr. Pascucci was entered. There are a number of other procedural arguments that we raise, but oral argument is a precious resource, so I'll rest on my brief on those. We also asserted this case, the case here is a takings case, and it rests very much, the heart of it is...
I'm sorry, I didn't catch it. Is a what case?
It's a takings case, Your Honor.
Okay.
The town, having obtained in the 2014 case a judgment entitling them to possession of the unit and ordering the Pascuccis to pay the town $1 for the privilege of having lost their marital house, we argue that this amounted to a taking.
I thought their marital house was another single-family property that they had bought and renovated.
This is their original marital house, which they bought. They won an affordable housing lottery in February of 1995, and they moved into and signed the deed in April of 1995. Subsequently, circa 2008, I believe it was, they bought a house on Kenniston Road, which was one of the genesises of the town's case against the Pascuccis in 2014. In 2014, the town alleged the Pascuccis were no longer primarily resident in the unit at Partridge Lane. They also argued that the Pascuccis were renting it out contrary to the deed lease. The complaint in this case argues that, among other things, that intervening decisions by this court have changed the law, as well as the fact that certain regulatory changes, but these are arguments that the lower court in this case never reached. We brought a regulatory taking claim arguing that this case's decision in a Boston affordable housing case on identical state forms meant that you could do what's called subsistence renting as long as you weren't making a profit if you happened to be physically present, and since difficulties with his wife and was on some occasions the sole and only resident at Partridge Lane while his wife resided in the much larger single-family home on, I think it's acres zoning, on Kenniston Road in Lynnfield. The earlier judgment is essentially void, and we understand that judgments being void of law, it's a nullity. It's the narrowest exception, but it protects a most important right, which is the right to be heard. And there really isn't any doubt in the earlier case that the Pascuccis were entitled, at the very least, to that oral damage assessment hearing. They even showed up at an extra hearing to be careful. They were told that wasn't your hearing, another one's coming, and then they never got their oral hearing. And for that reason alone, we should have prevailed in front of the Superior Court in this case. We initially brought these arguments to the Superior Court right out of the gate on a 12C motion, and the Judge Lang, who had actually been heard the earlier case, decided that we didn't have enough material to support our 12B motion, and so then we returned to the Superior Court as kind of a cross motion against the town's summary judgment motion with what the lower court docket refers to as a due process motion. The difference between this 12C motion and the prior 12C motion was that we returned to the Superior Court with a transcript of all of the hearings of the earlier 2014 case. And the Superior Court, in relation to our due process motion, we believe erroneously held that the facts from the docket in the earlier case about who was served and when, about what types of hearings there were, about what types of notice were sent, was not a matter of law that the court could read on 12C motion, but was a material fact and therefore denied my 12C motion. I understand the 12C motion was arguably late, but because we were only asking the court to read the transcript and read the docket, it seemed like a most straightforward way of dealing with the case, particularly because it was deferential to the town if there was any kind of real question as to what was going on, but it doesn't appear that to have been the case. The Superior Court, instead of granting our due process motion, turned around and granted the town summary judgment motion. We initially viewed this case as a case turning on a matter of law, hence the 12C motion.
Let me ask you about that, because you filed your notice of appeal from that on November 13th, 2023. Summary judgment entered on 10/10/23, correct?
I believe that's what the docket says, Your Honor.
So that's more than 30 days. So what do we do with
Your
that?
Honor, if you include the 3 days for under Rule 6, as well as the fact that I believe the 30th day ran on a Sunday and the motion, the notice was filed.
I don't think so. I think it was a Friday, but I could be wrong.
I think it was a Sunday.
What if it comes out the other way?
If it comes out the other way, Your Honor, then we're left with the fact that the question as to whether the Superior Court entered judgment immediately following the summary judgment motion was whether it was final or not. Your Honor may recall that this is actually upon a separate and final judgment motion under Rule 54B, and the town has, on the other side of that argument, argued that we filed our motion, our notice of appeal prematurely.
Right, so it looks like, but as I'm looking at it, it looks like your notice of appeal was had the problem of being both untimely and premature.
Your Honor, how can that be?
Well, it came too late by 3 days, and it was also premature.
Your Honor, we are granted the 3 days under Federal Rule of Civil Procedure, or under State Rule of Civil Procedure 6 for mailing, essentially. So if you take the court's initial attempted entry of summary judgment as timely, or as the entry of judgment, then our notice of appeal is timely. We argued that in our opposition to the motion to dismiss the appeal. And that's where I draw from, my facts, Your Honor. That's the gust of the dates. We actually argued in the opposition to the motion to dismiss the appeal that we were timely as to what the Superior Court attempted to enter judgment, and even though there was a later, more perfected judgment, that even if we're premature, that under the Concord case, a premature notice of appeal doesn't, if it doesn't do any prejudice to the side, is treated as a harmless error.
Okay, but I understand you're talking about the judgment. I mean, so your notice of appeal, the notice of appeal that is operative in this case is paper 52, right?
Yeah, I believe so, Your Honor.
Filed November 13th, 2023.
Yes, Your Honor.
And at that point, there was still an active case in which judgment had been entered, but no 54B judgment had been entered.
Yes, Your Honor, no
So
separate
there's no
judgment.
final judgment.
Right.
So the 54B judgment enters on February 2nd, 2024.
Yes, Your Honor.
So that's 3-ish months after the notice of appeal is filed.
Yes, Your Honor.
Then your clients file the motion to reconsider and amend the judgment at the end of that same month, February of '24. There is no further notice of appeal. Am I right about that?
That is correct, Your Honor.
Okay.
The notice of appeal we filed was entered in November. We believe it was timely as to the October entry of the summary judgment decision.
Well, but you can't appeal a partial summary judgment.
When
That's not a final and appealable order. It only becomes a final and appealable order if a 54B judgment is subsequently entered, which did happen in this case.
The reason the case stayed alive was because there were also counterclaims dealing between the
Against Wells
Pascuccis and the bank.
Fargo,
Yes,
right.
Your Honor. The bank and the Pascucci subsequently reached an arrangement, settled and stipulated, and
I
dismissed the
saw
case.
that, and it was settled, and the whole thing was dismissed, and no notice of appeal was filed at that point either.
No, Your Honor. The notice of appeal was filed against the town as soon as it appeared that all of the town's claims had been disposed of. In terms of time, and we believe it was the November entry was timely as to the October entry by the Superior Court. Your Honor may see from the docket that it appears that the Superior Court clerk definitively tried to enter a judgment on the summary judgment decision. There is an entry for memorandum and order, and then 4 lines later there is a separate what's called the summary judgment. And if that is in fact the operative judgment, then we have timely appealed. Secondarily, our second fallback argument, of course, is the Concord case, that a premature notice of appeal doesn't do anybody any harm, and therefore it should be treated as harmless error. The town prevailed on its summary judgment motion, Rule 56, arguing essentially very much like we had held that there was not a lot of facts in dispute. Mr. Pascucci definitely did rent out the unit. There is no doubt about that. It's not in contest. The question is, did he have the right to do so? We're in a somewhat odd posture because although we believe that this case should be decided on a matter of law, we resisted the entry of summary judgment on a matter of fact. We offered a First Amendment retaliation defense. between Mr. Pascucci's supplemental affidavit, although apparently it was, even though it was served with the town, apparently it was filed a little bit late, and that error was discovered and corrected timely in the proceedings below. But also there were admissions from the town, which my brother very kindly included in his supplemental appendix, where the town admitted that they have never before attempted to enforce this. They've never, in the entire history of Chapter 40B since it was enacted in 1969, have attempted to evict anybody under it or to enforce a deed rider. Mr. Pascucci's supplemental affidavit lays out at least a bare-bones case that he has been retaliated against because of his local political supports, and that he is the first one to be treated so, which makes him automatically treated differently than anybody else. And so we argue under a pair of Supreme Court cases that essentially following retaliatory arrest theory, that under a retaliatory arrest claim as most recently perfected by the federal Supreme Court, you may be arrested and you may admit you were disorderly or that your protest was riotous or what have you, and still argue that you were wrongfully targeted. And we believe that the Superior Court erred in entering summary judgment for the town, even though this case very much turns on a matter of law, because of the First Amendment factual defense. My brother argues that it wasn't.
I saw no evidence in the record that the town had been aware that any other recipient of this sort of housing benefit had treated it in the same way as your client. Did I miss that evidence?
Yes, Your Honor. Well, it was argued in the record from an earlier case of this court. There is a case from this court, it's an unpublished decision called Peachy, P-E-A-C-H-E-Y, where the town perhaps by accident, allowed another one of the 6 deed-restricted units to fall out of affordable housing. Mr. Pascucci also in his supplemental affidavits, as well as in his deposition, although that was not part of the summary judgment record, specifically said that several other of the units in this development had fallen out of affordable housing and the town had not taken any enforcement action against them. So Mr. Pascucci's supplemental affidavit swears that he has been treated differently from anybody else. And there also, of course, is the fact that Your Honors may look to your own records and see the Peachy case that there is another unit where the town raised some kind of a defense as to the unit falling out of affordable housing when it was sold from one unit to another, but didn't take any kind of affordable enforcement equitable action like this. So Mr. Pascucci's affidavit, I believe, stands accurate as sworn on its own merits, but also as to the records of this court and the other courts. Does that answer that question, Your Honor?
Sure.
So in terms of, it's a little bit of a stretch to apply a First Amendment retaliatory action claim, but we laid out the elements as the Supreme Court gave them to us. As we noted in our brief, the Supreme Court has, while this appeal has been pending, has actually since given us another First Amendment retaliation case, which has appeared to broaden the doctrine quite considerably. But the Superior Court, even though this argument was offered in opposition to the town's motion for summary judgment, did not address it in its decision. It did not look at the fact that there was a real factual dispute that they should have answered in the town, although we appreciate that the Superior Court didn't hold res judicata and that it ruled on the merits. We believe that that was error for reasons in our brief. Thank you very much, Your Honors.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court, my name is Tom Mullen. I'm the Town Council for the Town of Lynnfield, and I represent the appellees. In 1995, the Pascuccis were eligible purchasers under Chapter 40B, and they were able to buy the unit at a 52% discount. That came with some strings. They agreed to conditions and terms, including the fact that the unit was going to be subject to the regulations of what was then called the Department of Housing and Community Development. Now it's Executive Office of Housing and Livable Communities, and those regulations required that the unit be owner-occupied at all times. It also came with the string of a deed rider, which forbade any mortgage or lease without the approval of the town and the state. The Pascuccis were at first a success story under Chapter 40B. With the leg up the program gave them, they prospered, and by 2005, they were able to buy a single-family home in Lynnfield for more than 5 times as much as they had paid for the condominium unit just a few years earlier. But they borrowed against the unit itself to help finance their purchase of this new private home.
Is that forbidden?
Yeah, again, you can do it, but only with the approval of the state and the town, and they didn't bother getting either.
You know, that struck me. It just, how would the bank loan the money? I mean, don't they read the documents?
You'd be amazed. I represent a number of towns, and we have horrible issues with 40B, not about the people who who are in the units, but the banks that close without doing their due diligence. I see this in numerous cases. So they moved to this new, grander house, sometimes leasing out the condominium unit, sometimes allowing their friends to stay there for free, sometimes letting them stay there if they pay utilities. In 2014, the town sued the Pascuccis in Superior Court to force them to vacate the unit so it could be sold to an eligible buyer. They were represented by counsel, they filed an answer, but they refused to cooperate at all with any discovery. So they didn't provide any documents in response to a document request. I went to court and got an order to compel the production. They ignored that. I noticed their depositions. They ignored that. Finally, I went to Superior Court and asked for the strongest possible sanction, and the court entered judgment for the town and the mortgagee bank under Rule 37.
And is your position, I think I know the answer to this question, but I'm going to ask it anyway. I trust that your position is that what happened in that case is not before us now, at least in the sense that no notice of appeal was filed in that case.
That's right, Joanna. Well, wait a minute. I'm sorry.
Our notice of appeal is not of that case, is what I should have said.
It is not. That's right. In fact, they did file a notice of appeal in that 2014 case, and the appeal was dismissed for want of prosecution.
Right.
So the town sent a notice to quit and attempted an eviction in district court. The Pascuccis removed it to housing court, and the housing court dismissed without prejudice so that the Pascuccis could bring their taking claim here or in Superior Court. This case is the taking claim in question. I submit that the court lacks jurisdiction, the appeals court does, because the Pascuccis filed their one and only notice of appeal before the disposition of their motion to amend the judgment under Rule 59. The notice of appeal, as you've said, was filed on November 13, 2023. On February 27, 2024, they filed a, quote, motion to reconsider and amend judgment, end quote, which expressly cited and said it was under Rule 59. Now, having filed that motion, the Pascuccis had to renew their notice of appeal if their motion was denied, if they wanted to preserve their appeal, but they did not do so.
What about the harmless error argument?
I don't believe that you can apply that here, Your Honor, because of Mass Rule of Appellate Procedure 4A3, which says a notice of appeal filed before the disposition of any timely motion listed in Rule 4A2, and that includes judgment under a motion to amend judgment under Rule 59, shall have no effect. A new notice of appeal must be filed within the prescribed time measured from the entry of the order disposing of the last such remaining motion. I've cited in my brief on page 15 your court's Blackburn and Baxter decisions saying that an appeal founded, as this one is, on a notice of appeal filed before disposition of a Rule 59 motion, quote, is a nullity and shall be dismissed. The cases that my brother mentioned, which take a more liberal view of an untimely notice of appeal, do not involve the rule of appellate procedure that is at issue here. Prior to filing briefs, the parties did spar over dismissal of this appeal, and in one of their papers, the Pascuccis cited cases saying that the appeals court has discretion to allow an appeal despite an untimely notice. Those cases, again, involve different situations than a Rule 59 motion. In particular, Those cases were cited when I was making the case that the Rule 54B motion established the need for a second notice of appeal by the Pascuccis. And my brother is correct that if your only error is you filed your notice of appeal before a 54B determination, the appeals court can be lenient. I have found no case permitting such leniency if we're dealing with Rule 59 rather than Rule 54. Let me turn to the supposed due process claims. Yep. Sorry.
Yeah, I had a memory that there was a recent case about this issue, namely the premature filing of a notice of appeal when a Rule 59 motion is filed. And there is a case called, an unpublished case out of our court that I think was taken up by the SJC, called In the Matter of the Estate of William Allard. I don't know. I think that the rule has changed, but I can't say anything intelligent about that. So I'm just going to flag that for all of us.
I think that's right. I think this summer there was a rule change, and assuming there was, how does that apply to this case? Would the plaintiffs get the benefit of that rule change or no?
I don't see how they would get the benefit of a rule change that occurred after their offense. And as turning to the due process claims, the Pascuccis claim that they were never served with the town's amended complaint in the 2014 case. This is just flat out wrong. They misunderstand, I think, the difference between service under Rule 4 and service under Rule 5. The original complaint was, of course, served under Rule 4. When later we needed to amend the complaint in order to deal with the bank and a raft of liens that the Pascuccis had allowed to accrete on the property, we had to file a motion to amend the complaint, and that was done served under Rule 5. Again, at all times, when we relied on service under Rule 5, the Pascuccis were represented by counsel who had filed an answer in the case, and who dealt with me, incidentally, in connection with discovery matters. I actually had discovery conferences with him. I filed a 9C certificate before moving for any kind of penalty for their obstruction. And further, the amended complaint did not differ from the original complaint with respect to anything concerning the Pascuccis. It was different only in how it dealt with the mortgagee bank and in that it added a number of liens that had to be discharged. The Pascuccis also claim that the court in the 2014 case failed to follow Rule 55 in connection with defaulting them. But again, they weren't defaulted for failure to appear. They appeared. They suffered an entry of judgment against them as a discovery sanction under Rule 37. And in that, they got all the due process they were entitled to. They, in particular, saw a motion for sanctions, which was served under 9A. I dealt, as I said, with their counsel. There was a 9C certificate in the record. Neither the Pascuccis nor their lawyer attended the hearing on my motion for sanctions. The Pascuccis claimed that they were denied an assessment of damages hearing. Well, there was no assessment of actual damages. There were damages of $1, nominal damages, just to have something in the record about the counts being awarded to the town. The real relief that we were seeking was in the form of judgment that was submitted, and which provided that the town would be allowed to sell the unit as part of its affordable inventory to an income-eligible family. The joint motion of the town and the bank for entry of final judgment was served on both the Pascuccis individually and on their attorney. By that time, I was starting to get nervous about about actual service, and so I erred on the side of caution. And while I ordinarily would never directly contact an opposing party, I did so here, sending, as my certificate of service reflected, sending these documents to both their lawyer and the Pascuccis themselves. The motion was not allowed until a month later. Now, it's true there was no hearing on it, but there was a month during which the Pascuccis or their counsel could have filed an opposition with the court.
Did you request a hearing in your motion?
I don't believe I did. But the Pascuccis could have. They then did try to vacate the default. They did so a year and 9 months after the entry of judgment, judgment as a sanction. And they moved to vacate it, which the court denied. And then lastly, as I mentioned earlier, they appealed from the final judgment, but they abandoned their appeal and was dismissed for want of prosecution. Let me briefly speak about the First Amendment retaliation claim. This was not pled in the complaint at all. I have not seen any evidentiary support for the claim other than the affidavit of Mr. Pascucci, which does not even claim to be on the basis of personal knowledge, as it would have to be for a Rule 56 hearing as we had. And it is full of conclusory allegations. They rely on 2 admissions which the town made, and for the life of me, I can't understand the significance of either of them. One is that one or more current or former town officials or employees or their family members have won affordable housing lotteries in the past, and the other is the town has not previously tried to remove anyone from an affordable unit. Both absolutely true, both absolutely irrelevant. I really don't understand. I can't argue the point about the first one because I don't get it. And as for the second one, it actually speaks to the outrageousness of the Pascucci's conduct here. I am grateful that we have not had anything comparable to the Pascucci's previously in Lynnfield. And incidentally, in the Peachy case, as I recall, that was kind of embarrassing to the law department of Lynnfield. Back, I must say, before I became town council, the Peachy's deed rider should have been recorded, and it wasn't. And we later tried to enforce, this is my recollection of the case anyway, I didn't know it was going to come up today. The town of Lynnfield actually did try to enforce the deed rider restrictions that are typically in these cases against the proposed sale of that unit. And we were quite properly told no by the appeals court. Believe it or not, we won in the Superior Court. And the buyer took it to the appeals court and we lost. So we did try to hold on to that unit. Lynnfield is among the 20% or so of the communities in Massachusetts that actually have achieved 10% affordability. And we're incredibly proud of that, and we fight very hard to maintain it.
I see your time has been up for a little while, Counsel. I think we can take the rest of it on your brief. Thank you.
Thank you, Your Honor.
That brings an end to our sitting. I would like to thank our court officers for their help and monitoring during the day, and the clerk's office and our law clerks, including our excellent timekeeper. We are in recess. Thank you.